We call 25 CR 947, the state of Texas versus Jeremy C. Coleman. I guess you're Charles.
Yes, sir.
Jeremy Charles.
Yes, sir.
You are here with your attorney and the state's attorney. Mr. Dusler, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment, what are we doing?
Counts 1 and 2 make it a state jail.
Because there's several paragraphs in this.
The misdemeanors make it enhance it to a state jail felony. Counts 1 and 2.
That's correct, Judge.
And then okay, what are paragraphs 3 and 4? Make it a third degree or second?
If it would be a third
Would be a-
degree, if the state,
Those are both state jails, so it'd be a third degree. We're just proceeding on state jail,
yes, sir.
is
Yeah.
that right? Okay. In summary, this indictment in paragraph 1 alleges that on or about June 25th, 2025 in Jefferson County, Texas, you committed the state jail felony of evading arrest or detention with a previous conviction. And paragraph 2 goes on to allege that you have been convicted 3 times at least in 2004, 2010, and 2023 out of County Court of Law number 3 in 2 cases, and in this criminal district court of Jefferson County, Texas, in 1 case, I was evading arrest or detention with the use of a motor vehicle, wasn't it? On that one, that's different than these other.
Yes, sir.
Was he just running from the police?
Yes, sir.
Yes, Judge.
Well, they keep catching you.
Sir.
They keep catching you.
Yes, sir.
Why do you keep running?
I'm done with it, sir.
Yeah, boy, I wish I had $1 every time I heard that, really. It's up to you to decide, really.
Sir.
Don't talk the talk, walk the walk on
Yes,
it,
sir.
do it.
Yes, sir.
Paragraphs 1 and 2 constitute a state jail felony. Do you understand that? Because of the prior convictions alleged of evading arrest or detention in paragraph 2.
Yes, sir.
So anytime you run, it's at least a state jail felony.
Yes, sir.
It means you face at least 180 days in the state jail, up to 2 years in the state jail, and a fine up to $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be sentenced to 15 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do we erase on these pads?
You have to hold the button down on the pin and the whole button.
Oh, yeah. Down here. You can't make this stuff up. It's more convoluted than ever. It's how, who'd have thought that's the way this would work, you know? Yeah,
How should there be that coordination?
I heard it. So, how do you plead to paragraphs 1 and 2, guilty or not guilty?
Guilty, sir.
You plead guilty voluntarily and because you are guilty.
Yes, sir.
And on paragraph 2, those 3 prior convictions of evading arrest or detention in 2004, 2010, and 2023 out of this criminal district court and county court at law number 3 respectively. Are those allegations all true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. If I can get to it. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into
No
evidence
objection.
without objection. It's in. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
If nothing further, I'm going to follow this and find that you are pleading guilty here in paragraphs 1 and 2 voluntarily,
Yes, sir.
knowingly, intelligently. That constitutes a state jail felony.
Yes, sir.
There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony. I so find you guilty beyond a reasonable doubt. I am following this agreement. You were hereby sentenced to confinement in the state jail for a term of 15 months. You understand what has happened today, sir?
Yes, sir.
Anything else to
No,
add?
Can I-
That is, yeah.
It's,
You want
it's like all my time that I've been sitting on account towards the state jail time. What is it that you?
You will be given credit for all time you have served in conjunction with your sentence. And you're not the first person who asked that. I find it ironic. You are worried about the wrong thing. We take care of our business. What you don't do is take care of yours.
Yes, sir.
That's what you need to be taken care of.
Yes, sir.
But we never have problems with it. You always get the credit. We're going to do our job
Yes, sir.
properly.
Yes, sir.
You just need to start following the rules and following the law and quit coming up here and worrying about everybody else's business. You need to take care of you.
Yes, sir.
Okay, anything else?
No, sir.
No, sir.
Oh, thank you.
All right.
Here. Now it's gone blank. Hold on. Don't figure it here, so.
We could do a super cut of just Judge Stevens complaining about those pads that they use there in Jefferson County, and it'd probably be like a 30-minute super cut. Crazy. Reminder, pinned chat, In the Blind with Mike and Dan, premiere live episode tonight, 7 p.m. Eastern, 4 p.m. Pacific. Please do join us. There's a link to that episode right there in the pinned chat. So head over there, hit the notify me button so you are with us when we go live tonight. That show's a lot of fun. Mike and I did the pilot episode about a week and a half ago, and that's available now. Long and the short of it, we've got no idea what the two of us are going to talk about until we start the show and it's presented to us. So a lot of fun. Find me 2 other talking heads out there on YouTube who do it quite that way. And that's what makes it unique. Anywho, while they rack up the next contestant there, let's go back to Judge DiSanto.
And yet Mr. Shelton who appears to be assuming.
Thank you. And Mr. Shelton, if you can please unmute and state your name for the record, please.
Timothy Shelton.
Okay, good morning. And today is the date for the arraignment in this matter as your client is in custody. Counsel as to the arraignment.
Wait for reading the client's name.
The court will waive the formal. You need to stay muted. 23rd District Court, you need to stay muted. The 23rd District Court cases, you need to stay muted. We'll waive the formal reading, enter plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on February 12th.
8:45.
8:45 a.m. Because I'm not addressing you right now, ma'am. You need to stay muted. Thank you. And counsel as to bond.
Your Honor, my client's not on probation or parole. He indicates that he does work with his brother out of the city of Detroit. I did tell him that he would not be able to return to the address while this case is pending because he does list that as his resident. He indicates he believes he can reside with his younger brother in Detroit as well, and be able to provide an address. Your Honor, considering that there'll be no contact provision, potential gainful employment and a strong family support system, I know financially he indicated that he doesn't have access to any funds at this time, so I'd ask consideration for a personal bond. Thank you, Judge.
Okay, and so Mr. Shelton, I know when I saw your name on the on the docket today, I was you've been here a few times before.
Yes, ma'am.
Yes, you were just here last year, about 6 months ago, correct?
Yes, ma'am.
And what happened with that case?
It was dismissed. I did my
I'm sorry?
It was dismissed. I did my time and they let me go.
Well, you did your time because you pled guilty, or it was dismissed because they were not proceeding forward?
I thought it was honestly, I thought it was dismissed because I did time. I don't really know.
Okay, just
I've been
can you pull
going
them
around
up,
since then,
please?
so I really
Okay.
don't know.
Okay, just a moment, sir. So I think it was from March of 25.
March of 25.
Yes, I think so. Yes, March 16th to 25, assault.
This is something from 20.
Okay, what about, okay, what happened with that one?
You get the disorderly. Oh, so it was from 2022, but it was handled in 2025, so that's what it was.
Okay,
He pleads guilty to disorderly, and then that 30 days jail, credit 30 days fine, costs against it.
okay, all right. And so, sir, you pled guilty and you had credit for the time served that you were in custody. So, where do you work, sir?
Can you repeat that again?
Where do you work?
Well, I don't have a residence where I work, but my oldest brother is an entrepreneur on the come up. So I just been helping him when he called me to help him fix on houses in the city. That's all I've been doing.
So you are working, but not steadily.
Yes, ma'am.
Why aren't you working steadily, sir?
Well, since the last time I got arrested when I was in Lincoln Park, I don't have all my things, like far as to be able to get a regular job, because all my things was burnt up. In 11798 West Side Drive, so I've been trying to make a little money here and there to get my social, my birth certificate, and be able to move forward in life. But all I got is the ID, so ain't no job gonna hire me with just the state ID.
That's not accurate, sir. As long as they can identify you as an individual, you can still be hired. People hire people all the time with state IDs without a driver's license.
I've been
If you were to
trying,
test right now, if you were to test right now, sir, what is in your system?
marijuana and probably beer.
Do you have a prescription for marijuana, sir?
Years ago, before it was even legal.
Okay, so currently it's not valid, correct?
Yes, ma'am.
Okay, and so, who is Miss White to you?
That's my son's mother.
Okay, do you reside at that home?
Yes, ma'am.
Okay. Have you ever failed to appear in court for any reason, sir?
No, not that I know of.
All right, well, the court has some significant concerns for the safety of the victim in this matter, based upon the allegation in the police report. The court also has concerns that there's not another address that Mr. Shelton is able to provide with where he would be able to reside other than Orange Street. The court also, wants to make sure that Mr. Shelton's going to appear in court.
I will. With no problem. I will.
Well, we had a matter here from 2022 that it took you 3 years to handle, sir, before you came back to court. And so the court's going to order, based upon all that, the court's going to order a $15,000 10% bond with the following bond conditions. You are not to have any contact with Alexandra White, no phone contact, text message, email, social media, third party. At this point, you're not even going to be contacting her or having a third party contact regarding anything with your children. The court's going to also order you not to enter the property on Orange Street. You are allowed one visit to obtain personal belongings so long as you're accompanied by a police officer. That means you contact the Wyandotte Police Department before you approach the home and you go with them to the home. You are not to possess or consume any alcohol or drugs that are not prescribed. You're not to possess or have access to any firearms or any weapons. And you are not to be released without a GPS tether through Wayne County Jail. Any questions?
But the way I make money is at her house. My phone is at her house. So it's like, is it something y'all can do? Cause I got like $2,000 worth of tools at her house that I make money with. And I
So
got my phone there.
I've just
So-
indicated you're not to have contact with her. I've also indicated you may go to the home to obtain personal belongings one time accompanied by the police officer. So that phone would be considered personal belongings.
Well, I can't call y'all if I don't have my phone, man. That's all I'm saying. I
Okay,
can't call if I don't have
sir,
my phone.
contact your brother. You work with your brother. I presume you would know his phone number. We'll see you back on February 12th. Have a good day. We are on the record in.
The question of court, the question of course is, does the entrepreneur on the come up have a cell phone with which to contact? I have no idea. Let's continue with Judge.
If you're up, my client approaches and stands to my immediate right, sir. Can you state your name for the record, your voice out?
Michael Survey.
All right, thank you. Please keep your hands out of your pockets. And you probably win the award for the oldest case today. Sir, these matters are from 2016. So I'm glad that you're here to take care of these today. Counsel asked the arraignment.
On both cases, you made formal reading. My client stands with you.
Court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial.
Your Honor, we were able to work a resolution in which the case ending in 3049, driving license be dismissed in exchange for my client tendering a guilty plea to a lesser included charge of allowing an unlicensed person to drive in case number 16-1463.
Okay, well, I have that, I have it reversed. I have 1463 is dismissed and 3049 is allowing licensed driver to drive.
Judge, and that reflects
Okay.
offer that the prosecutor is tendering and we are prepared to accept.
Sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes,
All right, and you heard the very generous plea your attorney was able to work out for you, correct?
yes,
As to the amended charge on 3049, allowing a licensed driver to drive, how do you plead?
guilty.
You've gone over your rights with your attorney, correct?
Yes,
And you understand all of those rights.
yes,
You also understand by entering into a plea that you'll be waiving some of those rights.
yes,
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
yes,
Knowing all of that, do you want to continue with your plea?
yes,
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
no,
Any immigration issues?
No, Your Honor.
All right, counsel, if you can please vote to your client.
Your Honor, may I have the date of the offense on the 3049, please?
August 29th of 16.
Alleged extension to August 29th, 2016. Were you operating a vehicle in the city of Riverview?
Yes,
And when pulled over by the police and asked to provide a valid driver's license, you were unable to do so. Is that accurate?
that's correct.
So in the sense you allowed yourself to drive knowing that your license was not valid at the time, correct?
That's correct.
And you do have a valid license today. Is that accurate?
Yes, that's
Satisfied, Your Honor?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge on 3049. The court will dismiss the matter on 1463. Sir, there will still be, I believe there's a warrant fee and clearance fee on that one that was dismissed. As to sentencing on the 3049, counsel.
Yeah, and I asked my client why he took so long for him to come to court. He indicated that he did have some outstanding issues, and admittedly so, he lost track of this particular case. But when he went through the arduous process of getting his license back, he did notice that these were outstanding warrants, and he took it upon himself to make the necessary arrangements to come to court. My understanding that he has a strong family support system, a valid driver's license. I respectfully request that he be given cost and fines, and if necessary, a payment plan. Thanks, Judge.
All right, thank you. And sir, your license is valid today.
yes.
And are you on probation or parole anywhere, sir?
Nope.
Do you have any other matters you're out on bond for?
No.
Okay, the court's going to order 3049 statutory $100 fee, cost of $200, victim assessment fee of $75, justice system assessment fee of $50. That's for a total of $425. Is there a warrant fee and clearance fee?
Yeah, $50 warrant, $41 there.
Okay, so then the balance on those is, that one's $520. You did post the bond of $500, less the 10%, so there's a $450 balance. Bond balance that we can apply, which would leave $70 still due and owing. And since you posted a bond on your other matter, there should be that difference to be applied on the, 3049. Is there a clearance more fee on the other one as well?
Yeah, $100 warrant for the.
Okay, so that's a total of $145. And again, it was $250 bond, less the 10%, leaves a balance of $225. So you're right about that dollars that can be applied. So you may not have to pay any money out of pocket, okay? So just have a seat and somebody will be with you shortly, okay?
All right, sounds good. Thank you.
Thank you, Judge.
Good luck to you, sir.
Thank you.
Mr. Coleman, yep. Good morning. You're Jacoby and Dorsey. And Mr. Dorsey, in cause number 25 DCCR 1896, you're charged with a second-degree felony offense of manslaughter from November 17th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in the institutional division of the Texas Department of Corrections.
Your Honor, it's my understanding he has a prior felony conviction that's enhanced to a first.
That is the way, well, it's not indicted that way, Judge, but I will be seeking a repeat offender. I'll be filing a repeat offender notice.
I wrote first degree on there.
Right.
Because, and there's some confusion. He also explains that his underlying conviction is on appeal, I believe. That's what he tells me. So I told him I would check with the court to make sure that's right. It was 5 to 99 or 2 to 20, because I didn't know the status of all the other stuff.
If it's on appeal, then potentially that could be an issue with regard to it being a final conviction. So what can happen is if that appeal, once it's complete, and if they affirm that verdict and that conviction, and at that point, this would then potentially become, for punishment purposes, enhanced to a first-degree felony if that conviction becomes final. And I don't really know, the final conviction date, if that creates an issue because of the appellate process.
I'm not sure, Judge. I'm gonna have to look at it.
Judge, and I don't know the answer to that question.
Yeah.
But being familiar with this defendant, I tried him next door, involving several co-defendants. Ms. Duchamp and I did several years ago.
Okay.
He actually was on probation over there for cooperating with us for aggravated robbery involving an adjacent murder. He received 30 years on that revocation. I went back and double checked, and I'm sorry to interject, double checked that date. That hearing and that revocation was before this offense date. He had actually gone to Jefferson County Jail and was waiting on his 30-year sentence at TDC when this offense occurred in the jail.
And with that being said, Judge, the state will also be seeking, to the extent the law will allow us, to stack any sentence in this case on top of that 30-year sentence.
He's
But-
already filed the paper for that.
That 30-year sentence, though, is the one that is on appeal.
Possibly on appeal.
Okay, so I
If it's
guess
affirmed,
that's
I
the
think our
question.
position would be that the decision that was made that was then subsequently.
It would go back to the
affirmed would go
conviction
back to
date.
that date, yes.
That would tend to be what I would think, but we would obviously have to do a little bit of research to double check. And so I think that the most thorough way to do this is for you to understand that if that conviction is affirmed by the Court of Appeals, then it would appear that the conviction date then goes back to when that original conviction was, which was prior to the date of this offense. And therefore, it could enhance your punishment to that first-degree felony. If you go to a jury and they find that you're guilty and they find that conviction true, which means your minimum punishment would be 5 years instead of 2, up to 99 years or life in prison. Do you understand? In addition, if it's affirmed prior to any trial date or anything like that, and you're found guilty, Mr. Coleman can ask that any sentence that a jury gives you be stacked on top of or run consecutive to that 30-year sentence.
He's already filed that paperwork, Judge.
Okay, and that decision would be up to the court or up to me. So if you're found guilty, that could be a potential punishment in addition to yours, is that whatever the jury gives you, I could stack on top of that 30-year sentence. Do you understand all of that? I'm sorry, speak up. And I have a plea bargain rejection that you've signed here with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on just the count of manslaughter itself for a 20-year term in the institutional division. And that would be to run concurrently, that would be stacked.
That would be stacked, Judge. At least that's the offer as it stands. The state will entertain a counteroffer.
Well, I mean, that's,
I
okay.
get it, Judge.
I can't, don't know why anybody would
No, I
accept
get
that offer. So, do y'all want to visit a little bit more about this?
I can
and
talk to him
before
and
I
see
put
if-
it on a trial
I
docket?
can talk to him about.
Let me hold it.
possibilities.
Y'all visit a little bit about that before I take this
Okay.
to the trial docket. Ms. Perazzo, you have Jose Lopez Pamias? I think. Good morning. Good morning, sir. How are you? Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Thank you. Thank you.
I think we're going to move on. Translator hearings take forever and one day. Let's go to parole board, see what's going on in Louisiana.
February 3rd, 2026. My name is Cheryl Renatza. I'm serving as chair of today's panel. And my colleagues today on the panel are Mr. Chucky Tillis and Mr. Steve Prater. And our first remote location this morning is at Raymond Laborde Correctional Center. Good morning. Warden, would you and your staff please introduce yourself for the record?
Morning, Deputy Warden Stephen Bordelon.
Good morning. I am the trip nurse here, Annie McKnight. Raymond Heath classification.
Melissa Joshua Records. Right, thank you. And we have Mr. McCray here for us this morning. And Mr. McCray, let me just read some identifying information, and I guess he can communicate okay. How you doing, Mr. McCray, this morning?
Oh, pretty good, ma'am.
Well, let me just read some identifying information into the record, sir, and you can tell me if it's accurate or not. You are Lonnie McCray. Your DOC number is 446055. You're currently serving a 10-year sentence for aggravated battery out of East Baton Rouge Parish. You were sentenced in November of 2023. Your parole eligibility date is January of 2027, but you're here this morning because the facility has recommended you for medical parole. Does all that sound accurate to you, sir?
Yes, ma'am.
All right, thank you. So I guess Warden, either you or Ms. McKnight, can you just give us a synopsis of his health condition and if there is a suitable facility willing to take him?
Yes, ma'am. I'll get Ms. McKnight to kind of elaborate a little bit more on his medical condition. I would just say from my part, you know, he did come to us in September. You know, initially it was he was up for a medical furlough. At that time, he was approved for a nursing home, but I think that had expired. But I did talk to our records department. That's something that can be reinstated and approved, you know, if he is granted today. But if you want to know anything else regarding his medical condition, I'll get Ms. McKnight to explain.
So let me, so he's listed on our records, I guess, as a medical parole, but it's a medical treatment furlough. Is that what y'all are?
No, ma'am.
Okay. All right. Ms. McKnight, can you just give us a rundown of his situation?
Yes, ma'am. Last May, he was diagnosed with pancreatic cancer. These past month to 2 months, his condition has declined rapidly. He's total care. He needs assistance for transferring from bed to wheelchair, going on trips. He is now wheelchair bound. He needs assistance just to turn in bed. The only thing he's able to do is actually feed himself, but he is total care.
Okay, and in the information that we were provided, the life expectancy is less than a year.
Yes, ma'am. He has a poor prognosis. This is a terminally ill disease that he has.
Okay. And what do you what is the residence plan? Do you know?
It would be the Harmony House, a nursing home in Shreveport. They had accepted him back in October, but you know, a lot of time has passed, so we're gonna resubmit that, but they had already accepted him. His treatments are also in Shreveport that he's receiving.
Yes,
Okay.
ma'am. He goes every 2 weeks to EA Conway for his physician follow-ups, his cancer treatments. He has one next week as his next scheduled one.
Okay. And I don't have any other questions. Do my colleagues have any other questions?
I don't know.
All right, I think that based on the information that was submitted to us and that which we've heard today, we're prepared to vote, and I'll vote first. And by the way, thanks for the video. That was very helpful. My vote today would be to grant the medical parole to the medical facility once he's accepted.
I concur.
Mr. Prater?
I concur.
All right, so we'll get that to you, and if y'all work with the Harmony House, we'd appreciate it. Good luck to you, Mr. McCray.
Thank y'all, man.
So yeah, that seems like a no-brainer right move there. He's terminal. Let's get him into a nursing home and let him finish out his final days as comfortably as possible. Let's continue our efforts for 9 to 11% more Judge Boyd.
Here, I've got mine.
Oh, thank you. Just give me one moment. I'm pulling up Odyssey. All right, the court is calling 2022 CR 6941 State versus Crystal Cherry. Can I have parties announced?
Warren Wolf for Ms. Cherry.
And are you Ms. Cherry? Yes, ma'am. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Krista Colleen Cherry who's placed on deferred adjudication in 2022 CR 6941 for the offense of assault of a public servant on January 30, 2023 for a period of 2 years and extended for 1 year? Is that you?
Yes, ma'am.
All right, state you may proceed.
Violated condition number 4 in Bear County, Texas. The defendant, Crystal Colleen Cherry, did then and there failed to report to the supervision officer as directed for the months of September, October 2025 in violation of condition number.
How do you plead to that? True or not true?
True. Simple waiver.
Any objection? No, you're right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and revoke you and sentence you up to 10 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement or recommendation from the court? All right, state, what are you requesting?
Requesting revocation, Your Honor, and sentencing of 3 years.
All right, in defense, what are you requesting?
We'd ask that you follow the recommendation of probation to extend Ms. Cherry 1 year and put her in the state ISF cognitive program, that she needs more intense supervision. She has a lot of issues. She'd like to talk to the court about what's going on in her life, about her children being taken from her. She's on meds. She took medication this morning, but she's aware of what's going on and she's competent to have this hearing this morning.
But here's my question. This is not her first motion to revoke, and it's for the same issue.
Understood, and I see that, but she did not get the services that are being recommended now. She's been through quite a bit, and she really, it's a tough situation, and I'd like for her to explain to you why she was unable to report.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Crystal Colleen Cherry.
All right, so this is not your first motion to revoke. You've been here before for not reporting, and that was January 2024. And the court denied the motion, altered and amended your conditions to include the access program, the dual diagnosis with probation. So, and compliance with Center for Healthcare Services. So where did it all go wrong?
August 8th through 12, I was right. And I'm so sorry.
Have you talked to probation?
I told him everything happened. I went to Navy for a cold. So
All right,
I
so
get on the website.
let me stop you right there. This is what we're gonna do. Probation,
Yes, Judge.
can you look and see if she's ever had any contact with probation by phone or email, if there's no objection? By phone or email since,
She was reporting, and what happened was during this period
just
of
one
time,
second, since, if you'll look starting July 2025, is when are you saying you contacted someone?
I talked to my probation officer around that time, and I told him I was right.
Well, no. This is what I know. When, what time? Was it in August? Was it in
August.
August?
Yes, ma'am.
All right, so just give us a moment. I'm gonna have you take a seat. Your attorney will be able to speak with probation, and the state will be able to see if they have anything in the system.
Yes, ma'am.
Because it should be in the system, okay?
Yes.
All right, thank you.
Thank you.
All right, well, it sounds like she'll be back, so I'll keep an eye out for that. In the meantime, let's go back to Judge West.
0834, 1698 and 1909. Mr. Bates is charged with aggravated robbery, possession of a controlled substance, and obstruction or retaliation. And Mr. Radford, what is the announcement?
Judge, I have talked to Mr. Bates about his case and he wants to sit up for trial. Is that correct, Mr. Bates?
Speak up, please. And so, Mr. Bates, it looks like back in October of last year, you were here and you signed a plea bargain rejection where the district attorney's office made an offer of a cap of 25 years in that aggravated robbery case. which means you would go to, can I get y'all to hold it down, please? Hold it down, please. Which means if you wanted to take that deal, you could leave your punishment up to the court, and I could give you 25 years, I could give you less. It would just depend on the information that was brought to me. Again, you've got every right to reject that, and is that what you want to do and go forward with trial?
Yes, sir. It's true.
Okay, we will get your case set on the next available trial docket. Mr. Radford will begin preparation. All right, you can go back with the
Thank you,
bailiff.
Judge. May I be excused?
Yes, sir.
Thank you, Your Honor.
Thank you. See, Mr. Rojas, you've got Keisha Lewis. You've got Keisha Lewis.
Yes, ma'am, I just printed her.
Judge, I do have an update for you whenever on Mr. Young's case for next week.
On whose?
Be behind, Mr. from yesterday,
Oh.
the one you allowed me to make a phone call.
Oh, good, good.
It's on state and felony.
Okay. Good morning. Are you Keisha Lewis?
Yes. Judge, may I just ask the court two things before we proceed?
Yeah.
Can I make an oral motion to amend counts 1 through 4 and each motion to reflect committed the offense rather than arrested? We have discussed that upstairs, and everything that's been filed subsequently is correct.
Okay.
So I think
It's, if y'all catch them ahead of time, it's much easier for y'all to do it than me to try to do it on this computer. But yes, any objection to that, in each of the cases are the same?
No objection.
All right, let me get these printed out. It'll be easier. Sorry, it's taking me just a minute.
And Judge, also it is my intention, if the court follows this agreement, to have her plea to all 4 of those misdemeanors down the hall so that we can use them in the future for any enhancement purposes, and also to let you know I've spoken with her probation officer, Mr. Alex Hill, and he informs me that her case in Galveston County, that interfering with an emergency service animal, she did plead guilty to that, and they sentenced her to 1 year.
Thank you. Two motions. Thanks. Okay. Let me make these amendments first. And thank you for talking to them and getting these changed. All right, let me. That's today's the 3rd.
Some of it may have been just a misunderstanding for privacy.
Okay, now, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. Lewis, in cause number 22-40529, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the 2nd-degree felony offense of robbery, and that was a 7-year deferred probation. Is that correct? I'm sorry?
It was a 6-year probation.
Hold on, I'll go back and double check.
It's not just 7, right?
Administrative hearing trustee.
The deferred adjudication order dated January 25th of 2023 also shows 7 years. All right, so, so you were placed on probation January 25th of 2023 for robbery, correct? Okay, and in cause number 22-40528, looks like there is a first amended motion to revoke your unadjudicated probation in that case. Shows you were placed on probation January 25th of 2023 for assault on a peace officer, a second-degree felony, and that was also a 7-year deferred probation. Is that correct? Should I have a first amendment in each of these? Did I? Hold on a second. 5, 10, yeah, hold on, let me, I've printed out the wrong thing. Sorry.
But all the amendment added was that case in Galveston.
Okay. Just want to make sure. It just lines up the numbers better if I have them both, the right ones. I need that motion that I just printed, please. Each of these cases, looks like the state is going to proceed on counts 1 through 6 in each of these cases. Count 1 in each of your cases, or in each of the motions, alleges that you committed the new offense of evading arrest or detention March 12th of 2025 in Jefferson County, Texas. And is that true or not true? I'm sorry?
True.
And then count 2 in each case alleges that you committed the offense of resisting arrest, search, or transport March 12th of 2025. And is that true or not true?
True.
Count 3 in each case alleges that you committed the offense of theft of property March 12th of 2025 in Jefferson County. And is that true or not true?
True.
And then count 4 in each case alleges that you committed the offense of failure to identify or giving false or fictitious information. And is that true or not true? That's also on March 12th of 2025. And that's true as well?
Yes,
Count 5 in each case alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
And then count 6 in each case alleges that you failed to provide verification of entering and successfully completing the anger management program. And is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Right.
I have here on the tablet in each of your case some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Lewis is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, and cause number 22-40529, find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-40528, also find counts 1 through 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certification in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff.
Well, good morning.
Good morning.
Let me just for the record say we are at Dixon Correctional Institute. It is Tuesday, February 3rd, 2026, and it's 10:49 a.m. Good morning, Warden. Would you, for the record, introduce you and your staff?
Yes, ma'am. Good morning, board. I'm Dusty Bickham, Ward.
Down Cavalier classification.
Ashley Bradley, records.
Alvin King, reentry. Curtis Thurman, mental health. That's it.
All right, well, thank you. And we have Mr. Dowden. Good morning, sir.
Morning.
Would you introduce yourself? Tell us your name and your DOC number.
My name is Derek Dowden, DOC number 481806.
All right, sir, and let me just read some identifying information and we'll get started. You're classified, Mr. Dowden, as a second felony offender. You're serving a 30-year sentence. You were sentenced for armed robbery in Caddo Parish in August of 2006. You have a parole eligibility date, which is July 26th this year, and you have a good time date, July 21st, 2029. Is that correct?
Yes, ma'am.
All right, sir, your case has been assigned to Mr. Prater. I'm gonna turn it over to him.
Yes, sir, Mr. Dowden. You doing okay today?
Yes, sir.
Okay, good, good. Well, we need to talk about your case a little bit, and since you applied for this is your show. So we're gonna let you tell us, I want you to tell me what you did and what you feel about it and what you've done since you were locked up to make us feel like that you're a changed man. And then we're gonna hear from the warden, hear what he got to say, and then we're gonna hear from three folks that are in support of you. One is with the parole project, and then your mother and your aunt. And we'll hear from them, and then we'll ask you some questions, and we'll see what the decision will be, okay?
Yes, sir.
So this is your show, you've applied for it, and so I want you to, in your best words, tell us what you think about what you did.
Okay, in 2004, my drug addiction was completely out of control. And an acquaintance of mine introduced me to Brian for the first time. While I was at his apartment, I noticed that he had large bottles of narcotic pills. And I remember, like, a few weeks later, I remember just feeling desperate. I remember, like, feeling obsessed with going and taking those pills from him. And so I decided that I was gonna do it. And I didn't have a weapon, but I know someone who did. And I called him, asked him if he was willing to help me. He agreed. And so we went to Brian's apartment. Excuse me. I asked Brian to use the phone. He let us in. At that time, I pulled out a gun. The guy who was with me started to duct tape his wrists, his ankles. I asked him where the pills were. He told me. And on the way out, I noticed that he had a shelf of CDs, a PlayStation, and so I emptied a laundry basket and I put those items in the laundry basket and we left. And I would like to acknowledge for the board that though I know that the things that I took from him were special, I know that he worked for them, I'm sure that it took him a while to build up his collection of CDs. I want to acknowledge that
I know that I took a lot more. I took a sense of security. I'm deeply sorry for what I did to him. I know that it was traumatic. And the whole time I've been down, he's been in my prayers. I hope that he was able to recover. I'm not trying to offer up my drug addiction as an excuse for what I did. But I think back to every time I've gotten in trouble, every arrest, every relationship that I destroyed was because of that. And I don't offer it as an excuse. I take full responsibility for everything I've done. I know that I'm responsible. So to address the situation, once I came to prison, in Caddo Correctional Center, I was having a hard time at first. And the mental health director there, Dr. Flournoy, he told me that he was gonna put me in programs going, Foxtrot. And so I was able to get the help that I needed. I would go through these classes. I took them seriously because of I was able to go back also as a group leader. I was able to have contact visits with my son. We took parenting. I was a facilitator on parenting. I did Hazelden criminal addictive thinking. I also did a substance abuse. But unfortunately, at that time, before I went to DOC, I didn't fully grasp the substance abuse. I still struggle with drugs in prison. And when I went to David Wade, I tried to get in classes and they told me that I had too much time. So I started going to AANA and I have experienced relapse after years of sobriety. And so I went through that for a while and I ended up being transferred to Winfield. And Winfield was a drug infested facility. And I did relapse there. But it was in 2017 that I finally hit rock bottom and I knew that I had to make a change. I knew the guy over the Celebrate Recovery. So I went down there and as I began to do the steps, I realized that before, I was trying to do it on my own. And so I realized that I needed to give my life to Christ and I did. And I took that program seriously. I didn't just go through the motions. I received the information. I lived, talked it. I've been able to, I was able to go back as a facilitator and that helped me go through the program in service to others. I was able to experience it through another angle. And so I've been clean for almost 9 years and it's only by the grace of God. And I've continued in my recovery. I've been going to AANA here and I also go to church. I know that the only way that I'm going to be able to stay clean is through God. And what I've been doing in prison, it's worked. Meetings work. I take it very serious.
Okay. All right, well, thank you for that. That's, I appreciate that. That covered all the points I needed to as far as, what I like in the opening statement. Warden, tell us about this fella.
Oh, yeah, kind of hard to follow that one. Let's see. So I tell you, he's a trustee. He is a trustee here. He works at our dog pen. So he helps take care of our canine animals and stuff that we need for narcotic and chase dogs. Been there over 4 years. That's a job, been there over 4 years, does a wonderful job there. He also looking at his record, he's only had, I think, 4 write-ups in 21 years. So his disciplinary record is very, very good. Last write-up was in 2014. I do know he has a parole project backing him on this. Numerous classes, trustee. One thing in his faith, I will say, he talks about his faith a lot. He does go to church with the Healing Place group that comes in and stuff. I see him in that event. But one of the things he's known for is leather works, to be honest with you. He's a I don't know what the word is, a leather craftsman, I guess. He makes belts and things and slings and things of that nature. Goes to Angola for their arts and crafts. At DCI does our arts and crafts and actually fairly well known. I have people contact me and say, hey, who's that guy making belts? I need a belt made. So very good belt maker and different leather work. So anyway, he's done very well since he's been.
Okay, thank you, Warden. We appreciate that. All right, well, let's move on to, let's see. We got 3 folks gonna speak and, Ms. Paige Dowden, would you talk to us first? I think you're still muted.
Okay, yes, sir. We just got it unmuted. Okay, my name is Paige O'Pride Dowden. I'm Derek's mother, and I'm here to talk to you about Derek's life, all of his life, and the 21 years he's been incarcerated. Sorry if this gets a little bit long. I didn't have much time to get ready for this, so I wrote down some stuff last night I'm going to read. When Derek was a child, he was in Cub Scouts, Boy Scouts, and Christian school. He was a good kid. When he started high school, he began to act out of character, so he realized he'd started doing drugs. Years later, when he first went to prison, he got in trouble a few times, but eventually we began to see a huge change in him. He seemed like he was starting to finally get it. He became very involved in the church. We spent hours a month discussing Christian music. He talked all the time about his leather work. He worked in the garment factory. He became a professional at sewing, and he became very familiar with commercial sewing machines. Since then, he's so serious, he's acquired about $30,000 worth of tools, enough to run a professional shop out in the world. After we saw how serious he was, we had the opportunity to buy a commercial building on a major U.S. highway, so we bought it. It's already mostly paid off. This past October, Derek got a chance to go to the Angola rodeo and sell his products. And he called me at the end of the month and told me that he'd sold just under $13,000 worth of products in 4 days. That's impressive. So, which made us even more confident that buying the building was a good decision. I'll tell you a little bit what we have planned for him when he is released in the future. When he was released, he's going to have his own shop to come back to. We have a car for him, so he'll already have his own transportation. We've got furniture for him, brand new furniture, some of it's still in the box. So he's pretty much all set as far as that goes. He'll just need to buy a phone. We've also recently purchased a 10-foot plasma cam cutting table that his father needs his help with to build a metal building for it. So we're going to do some light manufacturing, and Derek will also have the opportunity to make products with this. Derek's father and I started selling products on the internet in 1998. So if Derek wants to sell products online, we can help get that set up. Basically, overall at this point, he's a really good person again. I'm convinced he'll do fine. He does have lots of remorse and regret for what he did. And he's always told me that he wished that he could apologize so Brian would know how sorry he really was. Besides the support he'll have from his father and I, he also has lots of relatives who'll be supportive, including his 22-year-old son, who he's really close to, and he speaks to him all the time. Derek has a really good work ethic, so I expect him to stay busy and do well. He plans to find a good church and continue to go to AA and NA meetings to keep himself on track for a positive life. And if he makes parole, we're looking forward to having him back home and helping him navigate himself into a busy, successful business that will provide for him for many years to come. in the beginning. He can work at our warehouse during the week if needed until he has enough income to support himself.
Okay, thank you. Appreciate that. All the preparations that you've done, your loving family. That's great. Okay, let's move on now and talk to the aunt. Is Miss Barbara Dowden.
It's Barbara Patrick.
Okay.
Dowden's the maiden name.
Okay.
I am Derek's oldest and favorite aunt. He and I have talked through his whole incarceration. He and I stayed in constant communication. We spoke either by letter or by technology. At least once a month we have spoken. So I watched him through all of this. He is only 5 months younger than my son, so I watched him grow up. Derek got into some typical young 20-year-old, mid 20-year-old stupidity and kind of went down a wrong path there. And over time, it took him a long while to realize he had traveled down the wrong path. But in the shop that he will come to, I got in 2015. And once he realized that there's going to be a place for him to come to, his attitude started changing. I watched him, I'm a seamstress, so him going into the garment factory and sewing and all, we talked about sewing machines, we talk about pattern making to design his own things, purses and belts and different things. We talked trade as to what he would want to do. How would he want to pursue manufacturing and marketing his products that he can make? I have a in-place customer base waiting for him to show up. That everybody knows that this is a sewing shop that I've told him I've sew anywhere from leather to lace. So he could do any type of sewing discipline that he would want to do, start his own whatever he wants to choose and do. Derek, I've been real proud of him. He has changed. He is not the arrogant young man that he was. He did learn that he didn't do what he was supposed to be or be the person, but now I think he's become that. He is he's responsible. He regrets his previous actions. He regrets the decisions that he made. And if he doesn't, then I'll just tell him he needs to. I think he's got a lot of potential once he gets out, to be able to make his own place in the world.
And it sounds like he got a lot of potential because of his family, and I appreciate that. Mr. Kerry Myers, tell us about your group and what y'all are willing to do.
Yes, good morning, Kerry Myers with Louisiana Parole Project, and we're here in support of Derek today. Derek's handled himself, I think, in front of this board and let you know his path through his incarceration, and the warden has spoken highly of him. About his faith and his recovery. I think while a lot has been said, and it's important about Derek's future and the support systems he has, the real crux of this is the work Derek's done. The work that's Derek recognizing the addiction, the damage that it did to his life, to other people's lives, the faith that he's grown in, and the maturity that he's achieved. Derek has served now 2/3 of his sentence. Parole Project is here to support his transition, which is the biggest obstacle, I guess, when someone first comes home. It's the most critical time in those first few months. And we are here to support Derek, provide him transitional housing, the programming he needs after 21 years of incarceration. Obviously, the world is a different place than the world was when he went into prison. That's where we're going to specialize in helping Derek make those adjustments with the support of his family. We will make sure he's connected to the sobriety plan while he's with us and when he moves forward. He's told you how committed he is to that and understands how important that is to the rest of his life. He will see our social workers and work with them. He will have one-on-one coaching through our case managers, technology, finance, social norms, how to interact, just socially. And Parole Project believes that Derek's future is one that should be served in the rest of his time in the community. While he committed a very serious offense, he has done the extreme hard work to get where he is now, and Parole Project wants to continue to support that.
Okay, thank you. Appreciate you and appreciate what your group does. All right, back to Mr. Derek Dowden. Mr. Dowden, you've heard what everybody said, and really, I don't have a lot of questions to ask you. The only other time that you've been in trouble was for drugs and absconding once you were on parole or probation for the drugs that you were on. And so this is the only violent crime that you've committed, although it was a serious crime. The DA is in opposition, the sheriff is in opposition, the chief of police is in opposition to this. The victim is not in opposition. The victim says that if we feel like as a board that you have rehabilitated yourself, then the victim says that you shouldn't have to spend any more time in jail. And so the victim is, and that's that's saying something about you. It's saying a huge amount about the victim. And so anyway, I don't have any other questions.
Yeah, I have one. You say you've been clean for how long?
I'm going on 9 years now.
Going on 9 years. Yeah, we like to see at least 10. You had a couple of relapses too, you said?
Yes, sir. And when that happened, I realized that I was trying to do it on my own. I tried to work the steps, but when I got to Celebrate Recovery, I realized that I didn't grasp it before, but step 2 is we came to believe that a power greater than ourselves could restore us to sanity. And I was trying to do it on my own. And step 3 is we made a decision to turn our lives and our will over to the care of God. And that's when I gave my life to Christ. And I took that program very seriously. We had daily devotion. And this wasn't just a program that you go to, it was a dorm that we lived on. And I have no desire to go back to that life. I just want to be a successful person. I have absolutely no desire to use, and I'm not.
You don't think if around your friends and stuff, you would probably relapse again?
No, sir. I'm going to be very picky about who I hang out with. I don't even want to see my old friends. That's not something I'm worried about, being around old people or anyone who uses. I will run as far away as I can from those people. Because I know what drugs have done to my life. I know what they've caused me to do. And I know that it was my choice. And I'm choosing right now to be free of that, just to continue my relationship with God. My mind is set on things like finding a church home. Because of my age and I'm getting out, my mind is actually set on things as, planning for saving money for retirement. Like my mind is on such positive things that I couldn't go back, sir. I'm 100% sure that I don't want that life anymore.
Thank you. I have no more questions.
Ready to vote?
I'm ready to vote.
Mr. Prater.
Okay, I've heard everything I need to hear, and I want to acknowledge a fellow that's deceased that you mentioned again, Dr. Cole Flournoy, who worked at the Caddo Correctional Student in charge of programs. You're the second or third, if I recall, person seeking parole that said their change started when they met him. He's been deceased now for a number of years, but he was a good person and a good friend. But thanks for acknowledging him, in addition to the others you acknowledged. My vote is to grant this request.
Mr. Tillis?
You said a lot of good things. And I hope you're sincere about it. My vote is to grant.
All right, Mr. Dowden, my vote is to grant to the parole project transition plan. I would offer you some caution though. You said in your talking to us that the meetings worked. And so I'm not going to require it as a condition of your parole that you do attend meetings. But I will tell you this, that we so often see people who stop going to the meetings because they don't think they need to anymore after having gone for a long time. And guess where they end up? Keep that in mind. We wish you the best success. Good luck, sir.
Thank you.
Mr. Kohler?
Yes, sir.
And you are charged here in 25, a CR 722 with a third-degree felony of illegal possession of a firearm by a convicted felon, which carries with it, you probably appreciate, carries with it up to 10 years in prison if convicted. Do you understand?
Yes, sir.
All right. Are you still at 109th Street?
Baldwin, Louisiana.
Okay, yeah.
Yes, Your Honor. Mr. Gown, we're still working through discovery. We're asking for one brief reset.
4 weeks, okay.
Yes, Your Honor.
And other than that case out of Harris County, that conviction out of Harris County, does he have anything else that you know of?
No, Your Honor, I don't have this.
See, I'm surprised that that was a felony. Actually.
No, sir, that's the only, see on.
Okay.
And he has a GPS monitor. I think he ordered it last time. He does appear, he has it on and he was.
All right, get a resetting for. Okay, thank you. Yes, ma'am. Ross Owens. Good. That's you?
Yes, sir.
And 25 CR 533 here, you, sir, are charged with second-degree felony of burglary of a habitation, carrying with up to a couple of years in prison. And what are we doing today?
Yes, Your Honor. Mr. Gown, we're still working through discovery as to on this one as well. I believe it's Kenesha's case and he wants to time to talk to her as well.
That's strict violations of these rules. You can only have one resetting during an announcement document. Or didn't we make that rule last time, James?
It only applies to Mrs. Haley.
Yeah, that's what I thought.
She has some time to
That's
be.
what I thought. It's not real old, and I'm like, granted, is 4 weeks going to be good?
Yes,
for
Your Honor.
everyone? And sir, are you still at 445?
Yes,
Okay. Well, please get a resetting.
Yes,
Thank
sir.
you. Thank you.
Pamela, first, good morning. Good to have you here. I don't know if we've seen you here before or not, but I'm guessing not because you're saying we're going to different courtrooms. That is what we do here at TCF Live. We move around the country. We check out different courtrooms, different perspectives, different cases. We don't just settle on one thing here. So sit back and enjoy.
Marsh here. That's you. And what about Sheena Miller?
She's here.
Is she in the custody?
No, she's in the back. She's legally dead.
That's her?
Yeah.
Okay, y'all can be seated. Hold on. Darren Porter,
He's here, Your Honor.
he needs to talk to me personally about it. Come on, Mr. Porter. Because I've told him, I've already had a long talk about the way this goes. And he's come right out of the box and is not following what we talked about. Okay, let's see. In 25 CR 335, sir, you or Darren Porter with Mr. Just a second. Yeah, he needs to, while I'm thinking about that, he needs to, I need to talk to him personally, because we had some chats and commitments and they're not being followed. On Mr. Macon, on Mr. Porter. No, okay, this is, we're in, this is a difficult one here. You're talking about habitual felon on this one? He's charged with a second-degree felony of burglary of a habitation. In paragraph 1, he's been convicted, it states in 89, in the old days, burglary of a building, which was a felony back then. And then thereafter, it alleges that after that was final, he committed the felony of sexual assault of a child, a second-degree felony, and was also convicted next door in 2005. And then now this happens. So if all of this is true, you're looking at a minimum of 25 years in prison, minimum to life imprisonment. You understand? Yeah, that's easy to understand. I mean, it's numbers, and you get punished not only for the crime but for criminal history. So criminal history can enhance the punishment range, and it does in this case. And that's why I always tell people, don't commit crimes. And I'd be out of a job, and I think I'd like it. It'd be a better world. That's what I want, a good world. I see in the file, the state has filed a motion to increase bond.
That's correct, Judge.
It was filed January 22nd.
That's what today is set for, you.
What is his bond?
You don't have that over 30,000.
Real quickly.
Michael, thank you for gifting a membership. Very much appreciate that. Joining us from the dentist office this morning, I assume?
Okay. Let's see where we are here.
We're prepared to go forward with a hearing, Your Honor, on these allegations.
What does that mean? I mean, a trial?
He's not, well, it's going to be a trial on the case in chief, but Mr. Ham has made some allegations that he's threatening or trying to interfere with a witness. And we're prepared to go forward on this.
All right. Go ahead. What do you want to present?
Yeah, my witness is outside the courtroom.
like to call her if you want to, I'm just checking to see if you want to do it from the table or from here or
This is
from the
fine.
tables.
This is fine.
Step call Mary Griffin.
This bond, I don't believe was set by me. I think it was set by Justice of the Peace in this.
Yes, sir.
And what's right off the bat on the four corners is the grand jury indicted you for burglary of a habitation, but you have a burglary of a building conviction in 1989. Burglaries are burglaries are burglaries. That concerns me.
He received a 5-year sentence for that, Judge.
I wonder why that didn't make an impact. I'm speaking rhetorically, why that wouldn't have made an impact. It's like touching a stove, you get burnt, you got 5 years imprisonment, right, for the burglary? Didn't you?
Actually, yes, sir.
Okay. Here you are for another burglary. Now, you're presumed innocent, but that can affect the bond because it's a similar type crime.
Griffin?
Raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Thank you. Go ahead. State.
Can you state your name for the record?
Mary Griffin?
And do you know a man by the name of Darren Dwayne Porter?
Yes, sir.
Do you see him here in the courtroom today? Can you point to him and identify something that he's wearing?
Well, for sure.
And may the record reflect you identified the defendant,
Yes, it
Darren.
will.
And how do you know Mr. Porter?
I was engaged to him. We lived together for 6 years.
So time is going to be relevant here.
I was going to ask you, I bet I stepped on what you got. When were you married to him? What period?
Not married, engaged.
Okay, what period of time was that?
From 2019 to February of 2025.
Okay, thank you.
All right. So, and that's where I was headed. The engagement ended a month after this particular charge. Are you familiar with the charge that he received of an offensive burglary of habitation that was supposed to have occurred on January 5th, 2025?
Yes, sir.
And has Mr. Porter had conversations with you about that date?
Yes, sir.
What were the nature of those conversations?
Mr. Porter informed me of his arrest, and I had already moved out at this time. And he asked me if I would be willing to write a letter for him stating what he wanted me to say, and he offered to pay me $100 to do it.
All right, so put it in common nomenclature. He was asking you to be his alibi witness?
Yeah.
Were you all
For a fee, yes, sir.
for a fee? And we actually talked about the amount of money that he offered you. Can you tell the judge what that was?
$100.
So not really much in the big picture of things, but he was seeking your testimony, asking you to basically be a paid witness for him as an alibi.
Yes, sir.
How did you react to that?
Well, then I wasn't gonna perjure myself for him.
And at that time was.
Did he ask you to perjure yourself?
Yeah.
Okay, maybe I'm stepping on you. Go ahead.
All right, so specifically, he was asking you to say what, ma'am?
He was asking me to specifically state things that were in the back of his truck, according to what he said were in the back of his truck when he left the house that morning, that were not there.
All right, so he was asking you to remember back to January 5th and state certain things about it?
Yeah,
And the things he asked you were untrue?
yeah,
And that's where your problem was, right?
yeah,
At that time, was he represented by a different lawyer?
yes, sir.
Did you advise them that there was a problem in that regard?
Yeah,
Who was that?
That was
Right.
Brian Lane, wasn't it?
yeah.
And you actually know his assistant
Lynette, yes,
and you talked with her about that, right?
yes, I did face to face and over the phone.
Specifically, did she advise you to just be truthful about whatever testimony there is?
She advised me to do not say anything that was gonna get me into trouble.
All right, so did you write the letter he asked you to?
I did not, he did not, I wrote a letter from what I know.
Yes, ma'am.
When he got it, he crumbled it up, cussed me, shot me the finger, and told me it was not what he needed for me to say. So
then I'm not gonna say anything, I'm not gonna lie.
So whenever you found out that we had this case here, did you actually contact me in regards to some of the things that were taking place?
Yes,
Did you volunteer to come in and give a statement?
yes,
And did you do that, in fact, via video?
yes.
Other
Have
than,
you had a chance to see that statement? Okay.
it's a part of the discovery, Judge.
Okay, I just was gonna make sure Mr. Macon has an opportunity to see that. When he wishes, thank you.
And in addition to that, did you provide text messages that you received from him about his attempts? I call it influencing your testimony, but obviously we're covering a lot of things here.
Yes, sir.
And have you told him you didn't want to be involved?
Yes,
Does he continue to try to contact you in that regard?
yes.
Hold on, help me out on dates or times.
So I'm going to get specifics if I could, Judge.
Go ahead.
In fact, I advised you at some point in time that I let his lawyer know what was going on and I had filed this motion to increase. Do you remember that? I told you for your safety, I'd let the lawyer know, kind of be aware that he may be contacting you.
Yes, sir.
What date was that?
January 26th.
How much did he
Year?
Yeah,
Okay.
How much has he tried to contact you since that date?
that was the date. He
Yes,
tried
ma'am.
to contact me.
Yes, ma'am.
I don't know, I showed you the text messages, 8 or 9, and a missed phone call that same day, because I didn't answer.
So all on the same day that we let the lawyer know and we filed the motion, he contacted you with 8 to 9 different texts and attempted to call you.
Yes.
Are you aware that I advised his lawyer that the contact needed to stop?
No, sir, I was not aware.
I didn't tell you that in our phone conversation?
No, you didn't tell me that.
Okay. May I approach, Jeff?
Yes.
I'm going to show you collectively what on the mark is, State's Exhibit 1. Ask you to look at that. Are these the text messages that you provided to our office?
Yes, sir.
Go ahead and look through them.
So this is quite interesting what we've stumbled in here too, just to bring you up to speed in
Yeah,
case you've
that's
joined
all in one
recently.
Right, so
This guy
since,
in front of judge for other charges, they're bringing up the fact that it looks like he tried to buy a witness.
I'll mark this as State's Exhibit 1. These are on for the darker colored format.
That's Facebook Messenger messages.
Thank you. That's what I was going to ask you. How did you receive these? By what method?
Facebook Messenger.
All right. So if we look at State's Exhibit 2, that's one with a lighter background. What texting message was this?
Regular phone texting.
All right, so this would have been on your cell phone. This was, which is States 2. States 1 is via a social media texting. How can you be certain that it's Darren Porter that sent you these things?
Oh, that's his name and number, so,
Had he contacted you via these means prior to
yeah,
this case?
for 6 years, yes.
So when we look at State's Exhibit 1, does it identify an individual by the name of Dwayne Porter as sending those messages?
Yes, that's his middle name is Dwayne.
And is that how you know him via the picture on Facebook and Facebook Messenger?
Yes, that's our dog.
Are the dates and actually on these, I see a time of 6:02. Do you know what date that was received?
Oh, that's from my phone, the time that I sent it to Mr. Turner.
Okay.
I mean, I could go back and look at the dates that were on it. Most of that.
Last page
That's
indicates.
August 4th. Yeah, most of these were during the summertime. That's right before his first court date he had. He was trying to get me to do the letter.
So can we assume that these are August 4th of 2025?
August 4th and before.
Okay. Let's switch over to State's Exhibit 2. This is identified as DP, Darren.
There.
Is that how you identified him in your cell phone?
Yes, sir.
These are notated with dates that appear to be August 4th and some times. Is that of 2025?
Yes, sir. Yeah, he went back and forth between the two. Was messaging me, alternating.
Thirty tender states exhibits 1 or 2. We have no objection. Then.
They are admitted.
All right, so let's start with states 1, the Facebook Messenger. What's the gist of what the judge is supposed to be getting here out of this conversation there?
Basically, it's him asking me, am I going to help him? Let's get down to business.
What is the help in the business?
Him wanting me to write him that letter. And then he's telling me in there that he's gonna compensate me for it.
All right, so that's the gist of States Exhibit 1. States Exhibit 2, around August 4th, where at some point in time, did you have him blocked and then unblocked him?
No, he had blocked me and then he unblocked me. And then he was asking me, was I at lunch yet? I told him not yet, but I was gonna be there shortly. And he said, okay. And then he kept on about asking me about, was I gonna help him? Are you gonna help me? Just tell me if you're gonna help me. I told you I would compensate you, all of that.
In fact, in this message, there's a reference about the offer I made him before, is there not? Is that a yes?
Yes, there is. That's all.
It's clearly talking about the situation and what he's dealing with, right?
Yes, sir. It's clearly talking about how, it was 25 to life and then 15 years and, yeah. Clearly talking about it.
This paragraph here, which begins with basically, is he talking about the facts of the case and the allegations here?
Yes, he is. And that's what he wanted me to put in the letter too.
All right, so he wanted you to say, basically, because basically, again, it's nothing but a point of a finger. Like I said in the first report, nothing is said about a house. The second report, all of a sudden, there's a window raised and a pulled the cord out that's two conflicting stories on 2 separate days. You just can't keep adding, especially on the first report. You have 5 more lines you could have used. I'm going to take a picture of both of them. And I think it gets cut off there and show you tonight.
Yes.
What's he referencing there?
He is referencing the victim's testimony.
That's right.
His written statement to the police. He said that it changed multiple times. There was one version in the beginning, and then it changed to an extension cord being taken out of the window. And that's what he was saying, that there was 5 additional lines originally on the first statement that the man could have put that, and he didn't, that he changed his story and added more stuff. And so that's what he was telling me about.
All right,
so I'm a little fuzzy here. Are you talking about the complainant? Is she referring to the?
Yes.
Yeah.
The complainant
in the burger of a habitation.
Yes.
And I'm a little fuzzy about this. What is the connection of the defendant to this building, this home?
That's unknown, Judge. I don't.
There's no connection.
What's the connection of the defendant to the complainant? here?
None.
Oh,
He didn't know the complainant and he does not know the house.
oh, this just chosen at random?
Yes, sir. There are other facts involved.
Okay.
All right, so
I didn't know if that was her home before
No.
or they were living in or something. That was fuzzy.
So these messages, and specifically that last little bit we were talking about, is him trying to get you to write that letter,
Yeah,
and which you've not done.
no,
And now that we brought it to the court's attention, what text did he send you on January 26th? Like, pull out your phone and read them.
Are you asking for State's Exhibit 2 to be placed in that?
I asked for both dates 1 and 2, and I believe there was no objections, Judge.
And they admitted, if I did it already.
First he tried to contact me via phone at around 2:35, January 26th PM, and I did not answer. He sent me a message on Facebook Messenger at 2:36 PM and just said my name, Mary. At 3:12, I messaged back and said, do not contact me again, as I was instructed by the DA's office. He messaged me again and said, what do I do with your mail? Now, I haven't lived with him in over a year, and he's just now asking me where to send my mail.
Didn't he specifically ask for your address?
No, he didn't.
Okay.
He just asked what to do with my mail.
Okay.
And I simply replied 3 letters, RTS, return to sender. That's all I said.
And that's the only reply you gave on January 26th of
Yes, sir.
2026.
Correct.
Have you repeatedly asked him to stop contacting you?
This was the last time I asked him to do not contact me. I have not replied to any of the other messages that came after that.
Have I covered to the extent of what he's talked with you about, ma'am?
Yeah.
All right, I pass the witness.
Go ahead, Mr. Mason.
Ms. Griffin, you had a 6-year relationship with Mr. Porter,
Yes.
and it ended, and he subsequently got married to another woman, correct?
No, that's not how it ended.
Did he get married to another woman?
I don't have any idea what his personal life is.
Okay. Didn't you and Mr. Porter have a bunch of controversy over $10,000 that was missing?
No.
Didn't he loan you $9,000 for your son?
No.
Yep, okay. But she's denying that, but
Yeah.
I'm curious what that has to do with the subject matter how's that related to this hearing anyway? I'm lost on that one, but she's denying it, so. And the questions of attorneys do not constitute any evidence.
I'll pass the witness.
I have no further questions of this witness. I ask that she be excused.
Let me, before that
Yes, sir.
happens. What is the relationship to this witness in the state's case here in this indictment? If any?
She wasn't going to be a witness until she reached out to me and told me that he was trying to purchase her alibi testimony. So I'll be bringing her in the state's case in chief if this case goes to trial.
And you're talking about this burglary of a habitation indictment
Correct.
in this cause number we're here for.
Anytime a defendant tries to solicit testimony via paid or otherwise, I will bring them in to come testify.
Mm-hmm. It is a crime if a person commits the offense of tampering with a witness, which is with intent to influence a witness. He offers, confers, or agrees to confer any benefit on a witness or prospective witness in an official proceeding, such as an indicted case in my court, or he coerces a witness or prospective witness in an official proceeding. And 1, to testify falsely is the first thing out of the box. Or 2, to withhold any testimony, information, documents, or things. And there are 3 other methods of committing such a crime, but I think what your testimony that you're standing behind is section 36.05, subpart A, subpart 1, to testify falsely.
Yes, sir.
And that is a felony of the 3rd degree, which carries with it up to 10 years in prison. If you have prior convictions such as these listed in this indictment, then you're looking at another habitual felony.
Yeah.
All right.
May she step down, Judge?
Yes. Do you need anything more from this lady? You may be seated. what's the state intending to do with that subject matter?
We don't typically like to intake matters at our office. I'll probably refer it to a separate law enforcement agency to finish the investigation and look at determining the filing of this additional criminal charge.
Anything else you want to add on this?
Not as far as evidence goes, Judge.
What do you want to,
Yes, Your Honor, I call Mr. Porter.
the defendant? Dennis, would you please tell the jury that we're going to need for them to relax, and it's going to be about 30 more minutes because of some matters that have arisen. Thank you. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? And do lower your hand, please. Go ahead.
Did you have a relationship with Mary Griffin?
Yes, sir, from 2018 to 2024.
Okay,
No, 2025.
okay. And did you talk to her about writing a letter, what was in the back of your truck?
So what has been,
That's a yes or no.
yes,
Then he can ask this next one.
Did you ask her to lie or tell an untruth at any time?
no, sir.
There's been talk about your offer to compensate her. Was that for the letter or for something else?
That was, for the letter, but the compensation was that I would still be there for her whenever she needed me, because she had just, called me and I helped her in the last 3 weeks prior because her son, I had no contact with her since March. And so she called me and, distraught because her son had a heart attack. And and if I'd be there for her, and I said, sure. And so compassionately I did. And, I gave her money for snacks up there at the hospital, so on and so forth, brought her food. And then afterwards, she said, well, what can I do for you? And I said, well, I need some help. I need you to help me out and be a witness, because you know what was in the back of my truck. And I said, I told her, and not so many words through the text messages, that I would compensate her, which meant I would still be her person, which is in that text messages. Had nothing to do with monetary value.
Did you subsequently, after breaking up with Miss Griffin, get married?
Yes, I did. And I told her I was getting married in November. She tried to call me back to get back with her on the November 24th. I told her there was no way, too much water under the bridge, too much control, too much trying to just keep me wore down, control. And enough was enough. And I went on to better my life.
So it's her, so with it, it's her fault.
Sir,
It's her fault.
I was I was so controlled that when I was getting my Class A CDL in February, 2 weeks before I went to take my test, she begged me not to take the test, and that she would give me $400 out of each one of her paychecks if I would just take the job that I got, because that way she could continue with the trackers on my truck, and there's no trackers on an 18-wheeler at my job. So therefore, she didn't want me to go anywhere. And I said I couldn't do it anymore, that I want to work. I've been a Boilermaker all my life, and I wanted to work, and I wanted to advance in this company. And I got my Class A CDL. And the day I got my Class A CDL, she left before I even got home from Longview from taking my test. And then there was nothing from March until June. He had a heart attack. She called me out of the blue. I'd be there for her. I said yes. And that was it. And I did not ask for any compensation as far as monetary value to get the letter. She said that she would gladly. And she wrote the letter. I have the letter. I gave it to Mr. Macon. I did not crumple it up, and I did not shoot the finger at her, what she said. It's intact. And there's no pieces from being crumpled up. Since then, she has, called and tried to sabotage our relationship. My wife has the text messages, and I've asked her to leave us alone. She knows we got married, and this is why she's doing what she's doing.
Hold on, I'm just. I'm a little confused here. This state's exhibit 1 that's been introduced, these are your statements, right?
Yes, sir. I don't deny any of it.
Okay.
It's just that I did.
Mary, please, are you going to help me or not? Everything else is frivolous. Sounds like whether she helps you or not is of primary importance to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate your helping me. You don't have to. That's why I'm going to compensate. That's the only thing we're dealing with right now.
Yes, there was.
That's pretty insistent.
There was phone calls in between the text messages, and we was talking, and then I would, and then she would get mad and hang up. But in those phone calls.
Well, hold on. I'm just fuzzy. What is it that you need her help with? Since everything else in the world, in your life, and the existence on this planet is frivolous, other than that primary need of yours. What is this primary need?
So that phone call consisted of.
What is your primary need that you're expressing in words here? You're going, please, are you going to help me or not? Everything else is frivolous. This is the most important thing right now in existence in the universe. What is this most important thing?
She asked how she could help, and.
No, what is this important thing that she, of what, sir? You're dancing around this issue. Helping you what?
Helping me with this case, because.
This case.
She knows I was innocent. She knows I was innocent.
I would compensate your helping me.
Yes, by being her person, and I have that in the text message. I will which means I will, anytime that anything goes wrong in her life and she needs me, I will be there. She always called me her person. Even the day she called and her son had a heart attack, I said, why you calling me? She said, because you're my person.
Yeah, I know you're making this sound so selfless on your part, but you say, are you going to help me or not? Everything else is frivolous.
Yes,
It's your need.
Talking about relationship.
We can talk over each other, and that would be inappropriate. You're going to keep speaking over me? Let me speak, then you can speak. Number one, it's rude not to, but number two, she has to take all of this down, and she can't take with 2 people to take it down. And you seem to be a very aggressive, controlling kind of person, but relax. Okay, you'll get your chance to be heard. Are you going to help me or not? Everything else is frivolous. That's pretty succinct. This is whatever this is that your needs are. If this is your need, it's more important than anything else in the universe, according to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate you helping me. That's the only thing we're dealing with. You're talking about compensating her to help you in this case.
Yes, sir.
You see anything wrong with that? Because when somebody is a witness that may help you, you have a right to get that. And they're subpoenaed and they come under oath, and based upon the sanctions that perjury can bring about, people better tell the truth. They don't get paid for being a witness generally. But what is it you're paying her to say?
I never offered to pay her. I always said.
Wait, that's, I would compensate your helping me. Didn't you say that? There it is.
And I didn't mean it monetarily.
Wait, what compensation are you talking about?
In return, my compensation would be to help her anytime she needed me.
Oh.
As I did.
Oh.
With her son.
Just being a wonderful guy.
And that was, yes, and I was.
Okay. Well, no, sir, you've been convicted of felonies twice. That's a character issue. Haven't you? I'm sorry. That's what the grand jury says, that you were convicted of burglary of a building, which is similar to what you're charged with, your burglary of a habitation.
Well,
And then, hold on, and then sexual assault of a child. You were convicted of that, weren't you?
And
Do you find that, is that true?
yes, sir.
Isn't that serious?
It's very serious.
Okay, all right, all right.
But by the second, can I say something? else?
Yes.
By the same token, on each one of those cases, it was a finger point and my lawyer's done nothing. Wright Kimbler, I sat right there in Walker's court and Wright Kimbler denied me and my 5 witnesses to testify, then straight up denied me.
So it's somebody else's fault?
Well, I was begging.
No,
him
no,
to
is it
testify.
yes or no? It's somebody else's fault.
It was Wright's fault.
Okay.
Or it was my fault because I didn't get a better lawyer. I didn't know how to get a
Okay,
lawyer.
but it was somebody who didn't do their job, but you have been convicted twice on two separate serious offenses, and you're saying that wasn't your fault.
No, sir, it wasn't.
Is that
I
right?
didn't get my
Or
day
no?
in court.
Sir, were you found guilty? You have a right to appeal. Did you appeal those cases?
Yes, sir.
And what were the results of the appeals? They were affirmed, weren't they?
No, sir. Brian Lane's still working on my.
No, sir. Have they been overturned?
I'm working on it.
Sure. Until they are overturned,
Yes, sir.
a conviction is valid
Yes, sir.
unless it's overturned.
Yes, sir.
You don't, I'd like to see the, the future that you're looking into, but and we're talking about a conviction, first of all, in 1989, that's 40, 30 some odd years ago, 37 years ago. And, that appeal is way out of time. So the only thing you would have would be a writ of habeas corpus. Is that what's being done?
I didn't try it. No, sir. It was a.
So you're not appealing that case?
No, sir.
That's what I thought you inferred to us a little while ago.
No, sir.
All right. Then the next one is 2005. That was over 20 years ago.
Yes.
You don't have much of an appeal at this time. You may have a writ, but an appeal is way overdue.
No, I started the appeal in 2018, 2 years after I got out. And
That
I
was-
had the money to get it.
Okay, isn't that 8 years ago?
Yes, sir.
Okay, what's the result of it?
I don't know what's happening. Yeah, I
Oh,
was down
well,
Brian Lane.
Look, a conviction is valid unless it's overturned. Unless that happens, you can sit there all day long and cry foul, but it's the way it is. But you have 2 convictions.
Yes, sir.
And they make up part of this case and its punishment, which subjects you to 25 to life. Anyway, we can beat this one a while, but State's Exhibit 1, which is part of the record, clearly states, and you've made it clear that you're referring to this case and you're willing to compensate her for help in this case. And that seems pretty clear.
Sure.
What else do you want to ask?
Questions from? The only thing I want to ask you in regards to just this issue, I've got plenty other things I'd like to talk about. But I want to know if you're going to admit that you texted her January 26th of 2026.
A week ago?
Yeah, just a week ago, after you found out about this motion, did you in fact engage in text that lady right after, just like she testified?
I had no idea.
Yes or no?
Yes, but I had no idea she made the complaint. I had no idea. I didn't know who this was. You can ask my lawyer. I had no idea.
You're going to tell me that this
Well,
one.
let him finish, please. Go ahead.
I had no idea. Yes, I've come to him and we thought this whole time it was another woman named Denise that stole $10,000 from her, my wife. I had no idea that it was this person at all.
So it's just ironic that the same day that you talked to him is when you reached out to her.
I reached out to her because I got a letter in the mail that was opened already and on the ground, and it said municipal court in Nederland. And I simply asked if she had a ticket that I'd help her with it.
I don't have any other questions.
With all your troubles, with all these fires, these raging fires that are occurring right now, you were worrying about her traffic, some municipal ticket. That's what you were spending your time on? Is that right? When you have all of this looking at 25 to life? You're saying you stopped what you were doing and were curious about whether she had a municipal city ordinance ticket?
That's what she felt. It's on the text message that she felt to
Okay.
provide that. Yes.
Anything else?
Mr. Porter, are you employed? Are you employed?
Yes, sir.
And whatever conditions the judge imposes in a bond, you'll follow those, right?
Yes, sir.
And you'll show up in court when you're supposed to?
Yes, sir.
If nothing further on.
All right. Go ahead. Anything else to add?
No, Judge, you've
Gotcha.
covered a lot of what I wanted to do, so in the nature of time, I'm gonna pass.
Summarize, what relief are you asking? And then Mr. Macon, what you respond to. Go ahead.
Judge, based upon the testimony from both witnesses today, I'm not convinced that there's a bond amount or conditions that can guarantee the safety of one, the witness that just testified, and two, the community in general. In that regard, based upon the motion to increase, I ask that Your Honor revoke the bond, which in my opinion was insufficient, and let's leave him waiting trial. But as for no bond.
Go ahead, Mr. Macon.
You know, we would naturally disagree. We think any bond Mr. Porter made, he would do. He would not contact anyone. He doesn't represent a danger to the community. He's employed.
All right. What is his bond right now?
30,000, Your Honor.
Okay. The court is going to keep you on a bond. Your bond, though, is doubled to $60,000. And you must have a GPS device at all times. Do you have one on you right now? You must have a global positioning device so I know where you are at all times. And you shall have, as a condition of bond, no contact with any witnesses in this case except through your attorney, Mr. Macon. And you can, of course, contact your own witnesses directly, but not witnesses who may be witnesses for the state. And we know that this lady was a witness for the state. Section 36.05 of the Texas Penal Code provides for felony punishment for any person who, with intent to influence a witness, offers, confers, or agrees to confer any benefit or of a witness or prospective witness in any official proceeding to testify falsely. Sir, it's clear, according to her testimony, that's what this is all about. And I'm going to ask the state of Texas to refer this also to consideration for a grand jury review. And the court finds that there is, based upon her testimony, that clearly meets those elements of that crime. The first condition of your bond is don't commit an offense. Any attempt to commit a crime or carrying out the commission of the elements of a crime constitute a violation of that bond. If this court discovers any further failings to follow bond conditions, then we'll bring you right back up here, and then it will your bond will geometrically increase, or it will be disallowed completely, and you'll have to be in custody until such time we have this trial. Are you setting this thing for trial?
Yes, sir. It is on the trial list.
Let's get it done. And I don't want to hear anything about attempts to influence witnesses. Work through your attorneys. He knows how to do things. That is all.
Deputy Warden Rochelle Ambo.
Reginald Admiral, classification.
Harmon Shipley, vendor records. Jody Sturgeon, program consultant.
Okay, thank you. Thanks for hosting us this morning. And our first case there at Angola is Mr. Jacobs. Good morning, Mr. Jacobs.
Good morning.
Would you introduce yourself, sir? Tell us your name and your DOC number.
Name is Zeandre Jacobs. Our DOC number is 447048.
Yes, sir. Mr. Jacobs, I'm going to read some identifying information into the record. But first, let me recognize we do have some folks here today. In support, we have Malcolm Matthews and Chris Williams, who'll be speaking on your behalf. I believe they're there with you in Angola. Here with us in New Orleans, we have representing the victim, Jamie Alexander, Yolanda Anders, Roger Dawkins, Roderick Dawkins, DeWanda Dawkins, and also the district attorney, Mr. Philip Terrell. And for those who've indicated they'd like to speak, we'll call on them at the appropriate time. First, let me read the identifying information, then I'm going to turn it over to Mr. Tillis because your case has been assigned to him this morning. So, Mr. Jacobs, you're classified as a third felony offender. You're currently serving a 60-year sentence. You were sentenced April 11, 2006 in Rapides Parish as a habitual offender for manslaughter. You have a parole eligibility date, which was September 7, 2025, and you have a good time release date, October 13, 2064. Is that information correct?
Yes, ma'am.
All right, and I do see we have Mr. Kerry Myers with the Parole Project on Zoom as well. Mr. Tillis?
Okay.
I did.
Okay. Good morning, Mr. Jacobs. How are you?
All right, sir. Real grateful this morning.
Good. Could you tell us why you're incarcerated and what caused you to be incarcerated? And why should we vote to in your favor, please?
Yes, sir. Well, always been my problem. I used to try to, I guess I can say, escape from myself, from my fears of my infidelities, not really knowing what was going to happen next in my life, the trouble, the bad decisions and choices I was making, starting from suspension from school to just straight out quitting, accidents, spending unnecessary finances, the trouble with the law, jumping from job to job, just a lot of chaos and confusion, and my anger. And my anger was angry because I knew I had the potential to do better and be better. But my irrational thinking at that time made me feel as if I was a failure and unable to talk to anyone because I didn't trust anyone and I didn't want to appear weak. So I self-medicated. I drank, I smoked weed, I popped pills, trying to avoid those feelings. And the only thing I was doing was really harboring the pain. And depression sits in, so I began to isolate myself. Some days I didn't want to be around anyone, talk to anyone. Some days I did. Then eventually, after holding all that negative energy in, the worst thing that could possibly happen happened.
What was that?
I ended up taking the life of this beautiful and innocent woman, all because I was unable to manage my life. For a long time, for a while, I'll say, I fought with the fact that I had taken a human life. The incident haunted me for years. I continued to get high while incarcerated, still trying to escape the reality of what I had done. But the remorse always come back. what I wanted was to find peace with myself. So after trying on my own unsuccessfully, I asked for help. The serenity prayer states, God, grant me the serenity to accept the things I cannot change, the courage to change the things that I can, and the wisdom to know the difference. By me allowing my life to become unmanageable, I took a human life. And I cannot change that. So I had to learn to accept it. But I was able to change from the person that I was.
Is that it?
No, sir. I'm sorry. I took a human life. And by doing so, I caused unimaginable and permanent pain to the victim's family, friends, and community. There's no excuse for my action. I take full and complete responsibility for them. My time here at Angola has been about one central goal: to ensure that the person who committed that terrible act is not the same person sitting before you today. My rehabilitation was my primary focus. I want to make sure my time spent was not time wasted. And even though I had an addiction problem, and addiction is a horrible disease, our lives are still predicated or determined by the choices we make. And on September the 5th, 2005, I made the worst choice imaginable. So instead of continue making these bad choices, I knew it was time for me to make some right choices. So that's when I got myself involved in different programmings, and surrounded myself around positive individuals, stopped using, and was able to share and trust with people. I also have a decent disciplinary record, 4 write-ups in 20 years. I think that shows I'm able to live within a set of rules and conduct myself with respect. I also have held the same job for over 16 years, which shows I can maintain employment. If released, I plan on living a quiet, productive, and lawful life. Plan on working to help support my family any way they may need, because they've always been there for me. I understand my freedom is a privilege and not a right. And I will not violate that trust you place in me. I'm not asking you to forget my crime. I live with the memory of it every day. But I wanted you to see that I have worked towards reform or rebuilding myself. Even though I can never bring Teresa back, I will spend the rest of my life proving to you that your decision to grant me a second chance was not a mistake. Thank you.
Thank you so much. We're going to come back with some more questions, but Warden, can you tell us anything about Mr. Jacobs, please?
Yes, Mr. Jacobs is a minimum aid trustee. He's assigned to graphic design. Like he said, he had a total of 4 DB reports his whole time here, the last one being in 2017. He has a degree in graphic communication. He has taken Cage Your Rage, Substance Abuse, 100 Hours, Inside Out Dad, Thinking for a Change. He did the Victim Awareness Accountability Letter. He participated in the STAR Substance Abuse Program. He just finished that on June 30th of 2025. He has a GED. He participated in a New Men Sober Group, and he also participated in 12 Steps Alcoholics Anonymous. We have had no problems here with Mr. Jacob. He has been a a model, inmate.
How long has he been a trustee?
He has been a trustee since 2014.
Thank you so much, Warden.
You're welcome.
Yeah, we'll, next, before we continue with our interview with Mr. Jacobs, we're going to hear from his supporters. Could we hear first from Mr. Malcolm Matthews?
Yes, my name is Malcolm Matthews. I'm from West Monroe. I speak today in support of Zeandre at his parole hearing. I want to thank him for the honor of asking me to do this, and also want to thank the board for listening to me today. I also want to thank the board for the tireless work you do in fairly deciding on the merits of cases that come before you. I have known Zeandre since last August, which is not a long time, but we met face to face today for the first time, actually. However, since August, our communications have been steady, sincere, and open. He's been part of the fellowship that I helped facilitate that serves as an outreach to 100 men here in Angola and other satellite prisons, as well as one woman at the Women's Institute. We mail out sermon notes each week from Dr. Patrick Mead of our Safe Harbor Church in Tennessee. Zeandre has been an active participant since day one, beginning in August, communicating his questions and comments. And he and I have talked also recently on the phone quite often. So I feel close to him, and I'm thankful I got to meet him today finally. Zeandre was recommended to me, and this stands out to me because he was recommended by a mutual good friend of ours, Mr. Milton Williams, who himself last December 3rd was granted parole here in this same room and was released from Angola. Milton and I speak almost daily. He told me that Zeandre is one of the best men he knew while he was incarcerated here at Angola. And then he further went on to say that of every man that he knew in prison who also knew Zeandre, every one of them had high regard for Z. I include that in my comments today because it speaks volumes to me that if he's held in such esteem where he is now, it stands to reason in my mind that he can carry that trait outside the wires of the prison and into society when he's released. Early on, Zeandre expressed to me, as he's expressed already this morning here, his remorse for the needless loss of Ms. Dawkins' life that he caused, and for the accompanying grief that has been ongoing for so many of her friends, her family, and his family and friends. He had a serious alcohol problem which contributed to the downward spiral of his life. He's talked about that. But he realizes and states that alcohol did not commit the crime. He committed the crime to take her life. And he faces that fact and owns responsibility for what happened. I'm in possession of his impressive packet of certificates of training and self-help classes that he's completed. And I know you have it too. I feel like he has used his time well and has redeemed his time well and redeemed himself as a human being. I think he's faced his demons and sought help to keep them out of his life going forward. And upon release, since alcoholism was a problem for him, upon release, he plans to join and maintain active attendance and participation with AA or Celebrate Recovery or a similar program to that to address that problem. So he can help himself and also help others in that same program. He and I had an instant rapport in that I'm a retired graphic designer, and that's what he's done at the prison for so many years, working in the area of graphics and signage and various projects. He's worked for the state DMV signage, municipality street signage, law enforcement decals, uniforms, T-shirts, as well as logo designs. These were done for several state agencies, police departments, and universities. In the area of logo design, he recently designed the STAR program, which has been mentioned already here at Angola. And the design was then adopted at the state level. And he's got that logo on his shirt today. I thought that was cool that he wore that shirt with the STAR logo that he designed. He wants to remain in that vocation upon his release. To that end, I offer him my name as a reference for entrance into schooling or employment after his release. He wisely, however, tells me that wisely he has taken other training. I think a commercial driver's license and some other training that he's completed to be job options as backups should that primary plan and graphics not work out immediately for him. So he's got his backups, and I think that's smart. So I plead for you to consider the accomplishments of this good man and the changes he has made toward a good life and service to others, and vote unanimously to grant his parole today. Thank you.
Yes, sir. Thank you, Mr. Matthews. We appreciate hearing from you. Mr. Williams, Chris Williams.
Yes, ma'am. How y'all doing this morning?
Good, thank you.
All right. My name is Chris Williams. I'm speaking on behalf of my longtime friend, DeAndre Jacobs. I know him as Tootie. That was his nickname, who I know for over 40 years. He has been a close friend since I was 9 or 10. From a young age, DeAndre stood out as someone who was quiet, intelligent, and dependable. He had his way of figuring out things, and whatever problems we had, we can go to him and he gave us some sound advice. He naturally became the leader of the group, and I looked up to him. Usually the quiet one always be the one that you stand out in the back, but he was in the front, but he was the quiet one. As we grew older, DeAndre continued to set a positive example. He was the first among us to learn how to drive. He was the first to get married. And personally, I witnessed how well he cared and took care of his family and his kids. He always worked hard and consistently held a job, taking pride providing for those who depended on him. One moment stuck with me and what he did for me. I needed $100 to secure my first car. The bank was closed. I couldn't get nowhere to get money, but I thought about my friend. I asked DeAndre, can I borrow $100? Because of course he had a job. He said, with no hesitation, he let me borrow it. He always was a hard worker. The act of kindness meant more to me probably than I realized the type of person he always was. Since incarcerated, DeAndre and I speak almost every Sunday. Our conversation, we focus on family, friends, and our kids, and the plans for his future. He speaks with hope and determination. He has shared his desire to pursue his career in graphic design or obtain a CDL license driving trucks. More than anything, he looked forward to reuniting with his family and being present for his 3 kids and his grandchildren. I truly believe he has grown to change for the better. He has a strong support from his family and friends, and he will continue to have strong support from us when he returns home. As a friend for 4 decades, I respectfully ask you to find in your hearts to grant DeAndre Jacobs a second chance. I believe he will use the opportunity to live responsible, productive, and a positive life. God bless.
Thank you, Mr. Williams. Could we hear from the Parole Project, please?
Good morning, Kerry Myers with Louisiana Parole Project. Here from Mr. Jacobs. Parole Project has accepted Mr. Jacobs as a client based on his institutional record. That includes job stability, 16 years on the job, 10 years of trustee status, He earned his GED, as you've heard, his disciplinary record, his participation in STAR as a new men volunteer mentor, his 330 hours of CTRP credit. He's just demonstrated the what Parole Project is about, and that's the capacity for people to change. So should this board grant his parole today, we will provide him the transitional services that someone who served 20 years in prison is needing when they return. That is going to include transitional housing, programming, life skills, financial evaluations by our social workers for his substance abuse and recommendations to be followed upon that. We will assist him in placing in any AA or other programs that he can join. So based on that institutional record, Parole Project asks this board to consider granting his parole today into our program.
Thank you. Thank you. We appreciate the work that the Parole Project does. Now we'll move on and hear from the opposition. And we have Ms. DeWanda Dawkins who'd like to say a few words. Amanda?
Good morning. I am Amanda Andrus. I am Miss Teresa's daughter-in-law, but I also, before I was her daughter-in-law, I grew up with her, so I knew her. I'm here to strongly oppose his release from prison, as I do believe he does not deserve the opportunity for parole or to reenter society. Teresa Dawkins was a beloved mother, grandmother, sister, aunt, and friend. Her murder has left an inconsolable mark on all of our lives. She was a kind and caring woman who dedicated her life to her family, and her loss is deeply felt by her 5 children, 13 grandchildren, and 2 great-grandchildren. The pain of her absence is something we carry every day, a void that can never truly be filled. Her death is also profoundly affected has also profoundly affected her brothers, sisters, nieces, nephews, and cousins who continue to mourn her loss and the life cut short. The trauma and grief we experience are compounded by the fact that her murderer remains a threat to society, and his potential release would cause further pain and suffering for all who loved her. While I acknowledge the importance of rehabilitation and second chances, I believe that justice for Teresa and her family requires that he remains incarcerated. The impact of his actions is irreversible, and I sincerely hope that the parole board considers the lasting harm done by his crime. Thank you for allowing me to share my heartfelt feelings on this matter.
Thank you for sharing those feelings. I think we'll hear from the DA now, Mr. Terrell.
Good morning, members of the Parole Board. Philip Terrell on behalf of the state of Louisiana, Ms. Teresa Dawkins, and the surviving victims. On September the 9th, 2005, Mr. Jacobs took the life of Teresa Dawkins. On that date, the Alexandria Police Department was called to the Alexandria Zoo. An employee reported finding a pool of blood, some female clothing that was torn, and some money. The APD officer examined the same and asked to view video surveillance. Detectives were called out to the scene, and the video showed a dark colored vehicle arrive between a zoo building and a male exit the vehicle. Next, a female walked around to the front of the vehicle and fell to the ground. She got up but fell again. Then the male was seen dragging the female by her legs back to the car and placing her in the trunk of the car. Another APD officer was patrolling near Gene Ball Drive, which is some distance away from the Alexandria Zoo, about 5 o'clock on the morning of the 6th. And he saw a car that he thought was being operated suspiciously. would slow down, speed up. And so he got behind it and was able to get the license number, but that APD officer received a call of a burglary in process, so he had to leave and go to that. Enough of the information off the license plate number for the detectives to trace it back to another person who told the detectives that Mr. Jacobs was allowed to use it, that particular vehicle. Then when the detectives contacted Mr. Jacobs the next day, he confessed to murdering Miss Dawkins and trying to attempt to secret her body on Gene Ball Drive in Alexandria. His statement to the detectives is particularly telling in this as to his motive. I don't know what came over me. I just had the urge to kill her. And the way he said he killed her was that he stabbed her several times as she was trying to run away from him. He caught up with her, stabbed her some more, beat her with a pistol about the head, and then shot her twice. Mr. Jacobs has had other run-ins with the law, as evidenced by the fact that he is was adjudged a habitual offender, and he pled to that as well. Mr. Jacobs was convicted, had a violent juvenile record. Mr. Jacobs was convicted of DWI 1, 2, and 3. Mr. Jacobs was convicted, pled guilty to prior to this incident, to a previous attempted murder. So he didn't get it right the first time, but he tried it, but he did the second. We are all about second chances. The habitual offender bill that he pled to says at the bottom, without benefit of parole, probation, or suspension of sentence, got 60 years with that concurrent with his manslaughter. He pled to all those things. There is a contract between these victims and the state of Louisiana. We promised them that we would send him to prison for 60 years, and we did. And I would submit, ladies and gentlemen, that it would be absolutely unfair to these fine people who weren't, one of them who works for the Department of Corrections. She was 14 years old when her mother was murdered. She didn't have a chance. Miss Teresa Dawkins didn't have a second chance, and these folks here did not have a chance to be with them. As to Mr. Jacobs' substance abuse, there are millions and millions of alcoholics throughout the world who don't commit any crimes, much less a murder and an attempted murder. He referred to the Serenity Prayer. Also, one of the tenets of any appropriate substance abuse treatment, particularly AA and NA, is that the person working in that program, the member of that program, must accept responsibility for their actions. He was given a responsibility for his action, that action 60 years. So I don't want to belabor, y'all familiar with the facts. This is not a drug case or a simple burglary. This is a murder by a person who attempted to commit a murder before and went to prison for 7 years on that. So what I would submit that for purposes of public safety, I would also submit that because what I feel like is a compact that the system and our office made with these folks, that he remain in prison. Thank you very much for listening to me. I appreciate it.
Thank you, Mr. Terrell. All right, Mr. Tillis, you want to continue your interview?
Yes.
Oh, I'm sorry. I don't know. Was there anybody else that needed to speak? I think not.
Mr. Jacob, how old were you when this crime happened?
31.
You were 31. We see, and I saw where you took a lot of classes. Which one impacted you the most?
I'd have to say the STR program. And the reason being, early in the morning, Ms. Laurie would do something called the a check-in. You go around the group and ask everyone how they was feeling. And it gave you the opportunity to state, how you were feeling, and if you had something on your mind to release it or whatnot. And I thought that was a good thing because as we go through our day-to-day and interact with one another, we always see the exterior of a person, the outside. We never really know what's going on the inside of a person. Some may look good on the outside, but it may be, tore up on the inside. The way you think, how you feel determines how you think. And how you think will determine the actions brought on by those feelings, whether they're good or bad. And I thought that exercise was real good because it taught communication, trust, and it helped build empathy. Because you were able to empathize with the next person. And I for one, started doing a daily check-in on myself because I knew how the effects of holding in those bad feelings, what it can do, what it can lead to. So it's good to share, and how you do that is by trusting someone, and you build that by communication.
Thank you. At what time I think you stated it earlier, what time did you realize when you were incarcerated that you needed to change your life?
Around in 2008. Well, I knew earlier when I was first incarcerated, is the reality of what I had done. The murder was just eating me up. That's why I was continuing to get high. But around 2008 is when I really came around and just cut ties on everything.
And that's when you started trying to rehabilitate yourself to change your life, to do better?
Yes, sir. Really got focused on it. I had started in 2007 when I first got my GED, but that's when I really got focused in 2008.
I see where you had a lot of classes. If you were released, what would you do? Where would you go? Where would you live?
Well, I was planning on staying in Baton Rouge, but I have down for stay with my mother in Rapides Parish, but I was trying to see if I could stay on longer with the parole board until financially able to get my own spot, because that's where I really would prefer to be in Baton Rouge. But I plan on taking an online course to get my bachelor's degree in graphic design. That's where I can work from home and self-employment if possible. I haven't gotten my CDL. I plan on getting my CDL when I get out. Because I believe we never have too many options. But I also plan on finding an AA group to sell into, to continue my recovery, and any other support group that I might come across that can help in my situation, or that I might can help.
Okay, you've done well. Any of my colleagues have any questions?
Mr. Prater?
No, I don't have any questions.
I have a couple of questions.
Yes, ma'am.
Mr. Jacobs, at the time of this crime, were you married?
Yes, ma'am.
What was your relationship with Miss Dawkins?
So I didn't know her.
You didn't know her.
No, ma'am.
And had you been in the drug court program previously?
Yes, ma'am. I got in there in 2003, and I had just finished in 2005, April 2005, I think it was.
Yeah, so you completed drug court.
Yes, ma'am.
And then,
But at the time,
you continued doing the same behavior in terms
yes,
of
ma'am. That was what I was about to tell you. I wasn't ready to stop. I was still with the foolishness.
So at what point in your incarceration did you come to terms with what you did? Because you still really haven't told us what you did. We heard from the DA and we heard
Yes,
from
ma'am.
Ms. Dawkins' family, but, and I don't want you to say it now, but I'm just wondering why you weren't real forthcoming about what you really did.
Oh, well, I thought you was, when you first asked about what led up to it, that's why I was going into that there.
Well, yeah, that was helpful too, but you never said what you did. Let's
Yes,
move
ma'am.
on. So, the warden said you did the victim accountability program. What
Yes,
did you
ma'am.
get out of that?
Well, I learned about the empathy more than anything was stood out the most. And that's dealing with to me, I do a lot of people trusting me to come to me when they have their problems or whatnot. And listening to someone share their feelings, and also being able to share your feelings, that help build empathy. So that's the main thing I was.
Good. So what do you think, have you had any victim impact training?
Meaning kind of.
Victim aware and accountability letter. You didn't have anything.
Yes, I'm confused with the question, the victim impact.
Yeah, that's a little different.
Oh, okay, I'm sorry,
What
ma'am.
was
No,
the
I,
impact on, what in your mind was the impact on your victim and the surviving family members?
I know for a fact I heard him. I know that's why I say there was a irreparable and permanent pain. I know that's a pain that would never go away. And that's why I say that I mean, now I cannot change that there. That's why person I am now, I've changed from that person who committed that horrible act.
Okay. All right.
I killed her. I'm very sorry for that. I'm completely sorry. But the person who done that is not the same person sitting here right now.
I believe that. All right, thank you. Any other questions? All right, I don't see any other questions, so I think we're prepared to vote. Mr. Tillis?
Mr. Jacob, I see a lot of change in you, and I see some remorsefulness, and you're on a good path. I'm impressed. But you've done 20 years of a 60-year crime, and due to law enforcement and family opposition, my vote today is going to be to deny.
Mr. Prater?
I concur.
Mr. Jacobs, I too believe that you have a path forward. You're doing the right things. But based on what we've heard here today and the length of time you have served is insufficient. My vote today is to deny your parole. But I want to encourage you to stay the course, continue doing community service within your little prison environment, and reapply whenever you're eligible to do so. Good luck to you, sir.
Thank you.
All right, I think that's the right choice and probably not a surprise. Let me see if this will work.
Denied.
I think it worked. You'll tell me if you heard the denied compliments of Michael Groff. Which, by the way, Michael Groff and I, in the blind tonight, 7 p.m. Eastern, 4 p.m. Pacific. There's a link in the chat. It's pinned up top. If you are new to the channel, Michael is our on-staff weatherman, for lack of a better way to put it, guest host when I can't do this show, and he also joins us on Sidebar, our panel show on Tuesday and Thursday nights. But In the Blind is a new thing. It has nothing to do with court, but it's all sorts of fun. So if you could, go over there, subscribe to that channel, and join us tonight, because it's a lot of fun, that show is. Let's go Michigan Judge Mom.
Today, Your Honor, I appear as Embassy counsel on behalf and with my client, Chris to my right, and this location and set for his arraignment pretrial. So please state your name for the record loudly. Gage Abrams.
Okay, and so today is the date scheduled for the arraignment and pretrial, as counsel stated, and as to the arraignment.
As to arraignment, Your Honor, I've had the opportunity to explain to my client the nature of both charges that he's charged with. He understands them both, all possible consequences, sentencings, and effects, be it from this court or any administrative agency. He understands those. At this time, Your Honor, we waive formal reading stand. You ask for a plea of not guilty.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And as to the pretrial.
Your Honor, after speaking to the prosecutor, my client wishes to avail himself of the offer and that he will plead guilty to the amended charge of operating while visibly impaired by alcohol. He understands what that entails. And Your Honor, if that plea is in fact accepted, he'll also plead responsible to the amended charge of no proof of insurance. As today, he showed me valid proof of insurance. And Your Honor, the prosecutor's motion will be dismissed the two original charges upon the acceptance of the plea as I've stated. With that, Your Honor, we're ready for the court's examination.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth? And you heard the plea that was placed on the record, correct, sir?
Yes.
You may lower your hand. And as to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct? And you understand all of those rights.
Yes, please.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues? Counsel, please go to your client.
Mr. Abrams, on or about January 25th, 2026, approximately 3 a.m. Were you operating a motor vehicle in the city of Wyandotte? Yes, sir. And prior to operating that vehicle, had you consumed alcoholic beverages? Yes, sir. You tell the court what you drank and how much?
Handful of.
I
I had a handful of IPAs.
And they're called Voodoo Rangers. Is that an alcoholic?
There's no talking in court.
Yes, sir.
Sorry.
Is that an alcoholic beverage? Yes, sir. And you consumed a few of those, correct? Yes, sir. Yeah, traditionally, not being a beer drinker, but I've heard IPA beers are stronger than regular beer. Is that correct?
Yes, sir.
Okay. But it didn't take long for you to feel the effects of it, correct? In fact, you drove in a way that you was following, police say, is following too close to the vehicle ahead of you. Is that correct?
Yes, sir.
You don't normally drive like that, do you?
Not at all.
Do you believe that the alcohol contributed to that decision to drive too closely?
Yes, sir.
And after you were arrested, did you take a chemical test at the police station?
Yes, sir.
Breathalyzer, correct?
Yes.
Will you stipulate and enter into the record that the result was 0.227 and 0.235?
Yes, sir.
I'm satisfied. Also, this is the insurance. Did you fail to show the police officer valid proof of insurance at the time?
Yes, sir.
But now it's been corrected. Is that correct?
Yes, sir.
I'm satisfied with that.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will dismiss the original charge per the plea agreement, the original two charges. And as to bond counsel.
Your Honor, my client has posted a $500 bond. He's not on probation or parole, nothing pending. And Your Honor, tell the court where you're working, please.
I work at Target full-time and I also go to school for my bachelor's in computer science.
And nothing.
Bachelor's with what?
Computer science.
Okay, and where do you attend school, sir?
Southern New Hampshire University.
So that's online?
Yes.
Presume you're not commuting to Southern New
No,
Hampshire?
sir.
Okay.
We asked for the bond to continue, Your Honor. I believe they'll reappear.
If you're to test right now, sir, what's in your system?
Cannabis.
Do you have a valid prescription for that, sir?
No.
When's the last time you used it?
Last week.
So you're not still under the influence?
No.
Moving forward, you're not to possess or consume any alcohol or drugs that are not prescribed. So your level is extremely high, and you're fortunate you didn't injure or kill somebody or otherwise.
I agree with you. Those are very stupid decisions.
The court's going to continue your cash bond. You're not on the bond in any other jurisdiction, are you, sir?
No.
What's happening with your matter in River Rouge?
That nothing ever really came from it. It was my girlfriend and I, or my ex-girlfriend and I had gotten into a little bit of a tiff. We used.
I don't need no factual information, sir, but you were charged with felony burglary, so that's not proceeding forward?
No, it was a misunderstanding.
Okay. And you're not out on bond in any other jurisdiction?
No, ma'am.
The court's going to order your cash bond to continue. You are not to possess or consume any alcohol or drugs unless prescribed. You are to have a sober link through the Wayne County Jail, testing 6 times per day. So you can do that. Where you report on your own, sir. You don't have to be taken into custody and transported down. So you're going to go over to probation. You're going to get the information regarding the sober link and when you have to go report to get that, and you'll get your next steps as well. Okay. All right. Have a good day. Thank you. Where's Mr. DuBois?
Okie dokie, friends. I'm going to take us back to Louisiana. We're going to do the parole board one more time. And then after that, I mean, it's going to go into hour 4 a little bit, I'm sure. But then after that, we'll have some discussion because I want to talk a little bit about the drunk lady in McNally's court today. Definitely talk about the guy in Stevens court. And I have a couple of interesting legal court-related news stories to share with you. But let's go to the board one more time.
Valenzuela there also?
She's not in the room. She's meeting with another client, Ms. Renanza.
Okay, thank you. So we have there at Angola in support, April Rodman, Mr. Fuller's sister, a brother Jason, his mother Miss Barbara Fuller, sister Delshonda Fuller, and another brother Robert Washington. On Zoom, you'll see we have Ron Hicks, and also here with us we have the Parole Project, Mr. Andrew Hunley, who will be speaking in support. At the DOC headquarters in Baton Rouge, which is usually where we are located, there is a room full of support. We have Taronda Woodard, Carl Garrett Davis, Chandrika Diggs, Terrence Wynn, Dwayne Jett. I believe they're all with pipes. Promise of Justice, Sarah Gonzalo, Michael Cahoon, and also Kara Crutcher, an attorney who are there in support. And for those who've indicated they want to speak, we'll call on them at the appropriate time and we'll allow them to do so. First, Mr. Fuller, I'm going to read some identifying information into the record and ask you to verify if it's correct.
Yes, ma'am.
So you are classified as a first felony offender.
Yes, ma'am.
You had a resentencing date in Caddo Parish in October of 2016 on a second-degree murder conviction. You're serving a life sentence with the eligibility of parole. So you were resentenced in 2016 to give you the parole eligibility. Is that right?
Yes, ma'am.
So the parole eligibility date was December 6, 2020. Is that your understanding?
Yes, ma'am.
Okay. And so I'm sure Mr. Lancaster has explained the process, but your case has been assigned to me. So I'm going to ask you a couple of questions. We'll hear from the warden and those who are in favor and support. And we'll hear from Mr. Lancaster, and then we'll have some more questions for you after everybody speaks. So first, just tell us why you're in jail.
I'm incarcerated because as a 17-year-old kid, I made a decision as a kid to first disrespect my mama. She woke me up for school one morning and she thought I was going to school. And I skipped school, took over from girls' house. In the process of me skipping school, I got with a friend named Kendra Williams. And I took him with me. We doing drugs, smoking weed, and we supposed to been going over some girl's house. And in the process of us going over some girl's house, Mr. Willie Brown. Mr. Willie Brown lost his life because of a decision I made to first skip school and then hang with him. Mr. Willie Brown lost his life because of that. And I'm responsible for that. Because if I wouldn't have did that, Mr. Willie Brown would have never lost his life like that. And to the victim, everybody that he left behind. And I'm sorry. I know I was a kid then. I know I was young. Man, I am so sorry. And I know I can't change that. If I can breathe life back into Mr. Willie Graham, I would in a heartbeat. And I know I can't. But I just want to say, man, I'm so sorry for the mistakes I made as a kid. I know I made mistakes in life. I know I didn't make the right decisions all the time. I made a lot of them. Even here, since I've been incarcerated, I didn't always do the right thing. For the life that was taken and me being responsible for that, I'm so sorry. But that's why I'm incarcerated on this murder charge.
Okay. We'll have some more questions for you in a little bit. Could we hear from the Parole Project, please?
Good morning, Andrew Hunley with Louisiana Parole Project. Here to confirm that James Fuller is a client of our organization. We've been working with him several years. I know his attorneys provided a brief and we'll give testimony later about his accomplishments. I can tell you our organization's committed to his reentry in the event that he is released based on his institutional record. We believe that all he has done, especially the programming that he started before he was parole eligible, before Miller and Montgomery, he started that track towards rehabilitation. It wasn't always a straight path, but he started it long before he was ever parole eligible. And even whenever he was denied parole, he continued to take additional programming. And he is a leader within the prison today. We can tell you that he recognizes that the best reentry plan isn't to reside in Caddo Parish, based on that's where he caused considerable harm. Parole Project's willing to take him into our reentry program in the Baton Rouge area and give him long-term residence as he works towards his reentry in the Baton Rouge area and not to return to a residence in Caddo Parish. If he's released to us, in addition to housing, we commit to long-term case management. As the board's aware, our organization has done the bulk of the reentry for Louisiana's juvenile lifers, and by and large, they've been ultimately successful, and we've been able to create a community of support for him based on his employable skills and the age he is now. We feel like this is the point where he can be released. He's still young enough to start a career, earn, and work towards self-sufficiency. In short, our organization's committed to provide long-term case management and support if he is granted release by this board today, and I stand by for any questions you may have about his reentry plan. Thank you.
Thank you. Thank you. Mr. Hicks, Ron Hicks, please.
Good morning to this honorable board. Thank you for giving me the opportunity to speak on behalf of Mr. James Fuller. I have known James for many, many years and seen how his life has been in a transition of growth from a perspective of understanding where he went wrong at in his life and trying to make the right decisions and put himself in the right place to get the help needed to be rehabilitated. Mr. Fuller, I consider him as my spiritual son. I've provided spiritual encouragement to him, spiritual counseling, heart-to-heart felt talks about how to move forward, how to be the person that God created him to be. And through those conversations that I've had over the years with Mr. Fuller, I've seen the progress that he's made. He's completed successfully a lot of the DOC approved programs within the prison. These programs address rehabilitation, they address personal responsibility, they address positive decision making, which is very reflective in Mr. Fuller's package, which Mr. Lancaster will talk about later. He's just demonstrated growth, continual growth, not growth and then stop, but a continual process of growing as an individual with the understanding that he can't undo the things that he's done, but he can be a person that can help shape the lives of other people in the future. Not only did Mr. Fuller take these programs, but now Mr. Fuller is also providing as a facilitator, guidance with other inmates, bringing them through the programs that was so helpful to him to get on the right path and understand the destructive nature that he once exhibited. Now being a more productive person, Mr. Fuller is guiding other individuals in that process. As you've noted, Ms. Renasser, at the beginning of your opening, you acknowledged the support that he had as it relates to family members. He has a solid family support system that's backing him. And as Mr. Andrew Huntley has stated with the Louisiana Parole Project, support from the Louisiana Parole Project is a plus. And I'm going to come alongside in any way that I can spiritually to help Mr. Fuller if the board sees fit to grant his parole today. I will stand by him. I will encourage him. I will continue to be a spiritual support and a person that will speak directly to him and try my best to guide Mr. Fuller in a direction that is so needed in our society to help other individuals, other young people to get on the right path. We need a Mr. Fuller here in Baton Rouge or wherever the board sees fit for him to live, to help other young individuals see the destructive nature of their behavior and get on the right path. And I think Mr. Fuller will be a great person to fulfill those obligations. In conclusion, I want to say that Mr. Fuller's rehabilitation, his leadership, his strong family support system demonstrate that he's ready for parole and prepared for success upon his release. Thank you so much for giving me the opportunity to speak on behalf of Mr. Fuller. God blessings.
Thank you, Mr. Hicks. And there at Angola, we have Mr. Fuller's sister, April Rodman.
Thank you.
You can sit down.
Sit down, she can hear you.
They can hear you.
Okay. Hello. My name is April Fuller Redmond, and I am the sister of James Lee Fuller. I am writing strongly support my brother's character. Having known James Fuller my entire life, I have maintained contact through phone calls and visitation during his time of being incarcerated. As I always remember, the role James upheld in my life as a big brother, I must say that has never changed. I am most proud of the many achievements James has been able to accomplish despite of his situation. Just to name a few, James has received his GED,
welding certifications, taking fatherhood classes without even being a father. That alone represents the type of love James withholds within his heart for not only people, but children as well. I have personally observed him being active in the work release program and highly looked up to by other inmates during visits while at Angola prison. Leadership has always been instilled in James from our growing up days when our mother would have to leave for work and James was left in charge over my other younger sibling and I. Even as a young child, I have yet to witness James or even known of him to have had any altercations with anyone of any sort. There is one thing I know about James. Once he put his mind to it, he would do it. I recall one of our most important conversations we had was him getting to know God. James made me a promise that he would cast all his cares upon the Lord and seek to follow God's will for his life. Without a shadow of a doubt, James held on to that promise, and the proof of that is us here today on James' behalf at this parole hearing. Upon release, I am fully and faithfully committed to supporting James Lee Fuller's reintegration into society. My main focus will be to take James on a visit to our family's church, United Outreach in Bossier City, Louisiana, to allow him the opportunity to be reconnected to God first by baptism. Everything else will fall in place under God's will for James' life. Thank you for allowing me to speak on my brother's behalf.
Yes, ma'am. Thank you for your remarks. Warden Ambo, could you tell us anything about Mr. Fuller?
Okay, I can tell you that Mr. Fuller, has been, a model inmate. He does have, paperwork saying that he completed a victim, impact letter. He just completed it on, 29th of January. I had it faxed over to you. Other than the welding, the STAR program, you know, he got his GED, Malachi Dad, what everybody else, you know, said to y'all and stuff like that. All I can say is that, you know, we have no problem here with James at, Louisiana State Penitentiary. And he has been a model inmate and he's ready to go back into society.
Thank you. All right, Mr. Lancaster, we'd like to hear your presentation.
Thank you, Mr. Renatza, Mr. Tillis, and Mr. Prater. As mentioned, James was 17 years old at the time the crime occurred. He spent 30 years here at Angola. He's now 47 years old. If you look at his time that he spent in prison, it does show a path where now he demonstrates maturity and rehabilitation. He's a Class A trustee here at Angola. That's the highest status, minimum status here. He is a resident of Camp F, which is the trustee camp. Since his last parole hearing, which was in 2020, he's done a number of things, and the committee at that time encouraged him to do more work, and he's done that. Primarily, he has participated in the STAR program, Substance Treatment and Recovery Program, and now he currently serves as a facilitator 4 days a week at the main prison for other people coming through that program. So it's been extremely impactful for him, and he's been able to share that with other prisoners who are entering that program. So I hope the committee has a chance to ask him some questions about his experience in the STAR program and as a facilitator. He's taken victim awareness. As mentioned, he's recently completed it. Thinking for a change again. He's got his carpentry certification since his last parole hearing, adding that to his welding certification, and he's continued to participate in Alcoholics Anonymous. All total, if you look at his institutional record, he's taken 13 programs that qualify for CTRP credit. Even though, you know, with his sentence, he doesn't accumulate CTRP credit, but he has taken those courses. He also volunteers for the Veterans Club at Camp F, which is a significant experience for him. He's not a veteran himself, but he's been doing that for a number of times, for a number of years. In that, he's found a sense of community. We know that juvenile lifers who have been released have been very successful on the outside. Part of that is the fact they have housing. Mr. Fuller will have that through the Parole Project. he'll have a job. The Parole Project will get him work. They also, a sense of community. He's built that sense of community here at Angola, and that will continue on the outside. Another thing that I think is important just to note is the level of support he has, both family support and community support. Those at headquarters who are in full support of him, as well as his family here. And of course, he'll have the support of the Parole Project. People in the institution who know him, Lori Stone, who is the STAR program coordinator in Mr. Fuller's annual review, commented that Mr. Fuller exceeds expectations, is enthusiastic and trustworthy. Colonel Fuge, security supervisor, commented that Mr. Fuller is no security risk at this time and follows penitentiary rules. Sherry Barton, the ARDC supervisor, commented that Mr. Fuller is polite, respectable, dependable, friendly, and has a calm demeanor. Mr. Fuller, I think, demonstrates that he'll be successful on the outside, and we pray that this committee grants him parole to continue to serve the remainder of his sentence under supervision in the community and continue to demonstrate that he is compliant with rules and has changed and will be successful. Thank you.
Thank you. And earlier, I failed to mention that we do have a representative from the Caddo District Attorney's Office, the Victim Assistance Coordinator, Ms. Leona Fitzgerald, and she would like to speak in opposition, and we'd like to hear from you now, Ms. Fitzgerald.
Good morning. Yes, I'm Leona Fitzgerald, and I'm here on behalf of the District Attorney, James Stewart, and the District Attorney's Office. Our office is opposed in this situation, and I do appreciate Mr. Fuller's comments and his acceptance of accountability for what happened. I don't want to go too deep into the facts of the case for that reason, but I do feel like I have to point out just how shocking and senseless this offense was. Mr. Willie Graham was a member of our community. This happened in broad daylight around 2 o'clock in the afternoon. There were eyewitnesses to this shooting, and I realized that he was 17 years old, but surely he knew at 17 that this was unacceptable. And basically, he chased Mr. Graham down as he ran away, and Mr. Graham was shot in the back twice. And he was still able to get up and run more for his life, and was able to flag down a stranger who drove him to the emergency room. So this was just sort of like stalking an animal, it seems. I'm glad to see that Mr. Fuller has his GED and has experience with welding, but I can't ignore his prison behavior, his 26 write-ups in the amount of time that he's been in prison. And yes, for the past 5 years or so, it looks like he has a clean disciplinary record, but it was terrible before that. And I couldn't help but notice that, Mr. Fuller was resentenced in 2016. And at that point, he became eligible for parole. And that is when there was a great uptick in his disciplinary behavior getting better. And also all the programs, I'm looking at these certificates here and all the classes that he took. And that looks like that was in 2017. So my question is, what was Mr. Fuller doing from 1996 until 2016? Was he taking classes? I have 2 certificates of completion that predate 2017. I have copies of 15 certificates since 2017. So in my mind, that's not long enough. I do think that Mr. Fuller is on the right path. I don't mean to dismiss all the positive things that he's done, but, this case is at the top of the list of the most heartless, dastardly murders that I've seen in all my years here. And so it's unconscionable to me how even a young person could plot to do this. This was not a youthful impulse. This was something that he and his co-defendant planned to do, and that he bragged to one of the eyewitnesses about, look, I'm going to go get me one. And so there were at least 8 shots fired. We know the victim was hit twice. This was an adult crime. And just because his sentence has been amended to allow for parole consideration doesn't mean that he's entitled to it, and that he shouldn't have to work really hard and have a long proven record of his rehabilitation. So, Mr. Graham left behind a family. They're not on today, but he had people who loved him. He was known in the neighborhood. This traumatized a lot of people, eyewitnesses, neighbors who were just out in their yard raking leaves and became witnesses to a murder. A 2-year-old that had to be grabbed and rushed inside for cover whenever these shots rang out. The lady who was driving down the street and ended up taking Mr. Graham to the emergency room. So these are the kinds of crimes that are far-reaching in our community. And we just think that at this point, Mr. Graham's life was worth more than 30 years. And, we want to see more continued progress by Mr. Fuller. At this point, we think that parole would be premature. And, as I said, Mr. Graham deserved better than to leave this world at the age of 53 at the hands of 2 young men that were looking to earn a quick buck at the expense of another human's life. And so we heartily believe that now is not the time for Mr. Fuller. We feel at this point that parole would deprecate the seriousness of this crime and cause an undue risk to our community. So I do agree with something that Ms. Renatza said in the last hearing, that he is on a path forward, and we respectfully request that he be kept on that path forward from Angola. Thank you for giving me time to share my comments.
Thank you. We always appreciate hearing from the DA's perspective. Thank you. All right, Mr. Fuller, I have some questions for you. Your case was, as I said, assigned to me, so I'll take the lead on the interview. When did you first start using drugs? How old were you?
I was around maybe 11, 12 years old when I first got introduced to it.
What were you introduced to first?
Marijuana.
Any alcohol?
Yes, ma'am.
Same age?
Yes, ma'am.
And so, why did you have a gun that day? Did you always carry a gun?
No, ma'am. No, ma'am. But that day is just, I guess coming up from where I'm from is just to have protection.
And that day was different for some reason. Well, because
Yes,
you said you didn't usually carry a gun,
no, ma'am.
but that day you just decided to do it.
Yes, ma'am.
Have you given that any thought?
Yes, ma'am.
Well, what you
A
think
lot.
about?
I think that I was so stupid as a young man. I think I made a lot of wrong decisions coming up in life as a young man. Decisions that today I see that they wasn't the right decisions.
Okay, so, you say you got your GED, right, since you've been
Yes,
there?
ma'am. Yes,
What
ma'am.
level, what grade did you finish in school? You said that particular day you skipped school. What grade were you in?
9th grade.
Ninth grade. Hmm. All right. Had you repeated any grades?
Yes, ma'am.
Tell me about that. Which ones?
I think that's the grade I failed in 9th grade.
Ninth grade, okay. So, when you had a hearing in 2020, I believe, as was mentioned, and what were the reasons you were told you were denied at that time?
I don't remember all the reasons, but I know at that time I was still in denial. I didn't take full responsibility for my actions. I didn't take full responsibility for using drugs. I was on drugs and I was in denial. I was ashamed and I just felt, I don't know. I just
So,
felt,
so you're saying you were on drugs as recently as 2020? Is that what you said?
I didn't use drugs since I've been here. Yes, ma'am.
Okay. When's the last time you did that?
Oh, I haven't did it now. It was before 2020, but I haven't done no drugs in years now.
Well, how many years? Most people know.
Since like maybe what, 2017, 18, somewhere up in there.
About the time you thought you might be eligible for parole. Is that what changed you? The hope?
I felt like I had hope again because I honestly thought that I was gonna die here. It's like nothing good has ever happened to me since I've been in the system, and I thought I was gonna die here. It's like I had no hope that this was my home.
Well, okay, so let's move on. I think that you were told at that hearing, I wasn't on that panel, but I looked at the record and I think you were told that you needed some substance abuse treatment, and the record
Yes,
shows
ma'am.
that you did you completed the STAR program. What'd you get out of that?
Oh, that was a life-changing event. Because through the STAR program, it taught me about recovery. It taught me about the core beliefs I had then as a kid and coming up now as a man. With the STAR program, a lot of men that have known me over the years here at Angola, they know my life then, even when I was smoking marijuana here. And they see the change in me now to where when they see me today, I get letters now asking me, what you did with your life, man? How you change your life around like this? Look, man, I need some help. Man, help whatever you doing, man, help me do this. And that makes me feel so good to be able to help another person because I know where you at, because I done been there. So look, come on, talk to me. And I will talk to them and I will introduce them to my facilitator. And we would do a survey on them. She would do a background check. And everybody, usually we wouldn't have number 8 people in the class. Right now we at 20. We don't go up under 20 because you have so many people from even the out accounts sending me word, telling me, man, I hear about what you're doing with your life. Man, I like what you're doing with your life. Man, how can I be a part of that? And I want to help because there's so many of my friends have OD'd up here and died off of drugs. And with the decisions I made as a youngster, now I can do something to help now. I can bring men this way. I can help get men off of drugs. That is a feeling I never thought I have, that I never thought I would love like this, to be able to help another man change his life.
Well, one of the questions I was going to ask you was tell me about your community service work. I think you just did that.
That was just a
And
part
also
of it.
your work with the vets.
Yes, ma'am.
That's
And
important.
a lot of times they might send a letter around to Camp F. We'll fill our name out to go over to Camp F and fellowship and talk to the brothers over there. We'll go over there and play them in basketball or flag football and sit down and eat with them and talk with them. I also do that. I also was getting with the brother Tyrone Glover. I became an active member of the round table with him. I asked him for help. Man, when I get out of here, can I help now? And if I'm eligible to get parole, will you help me when I get out there?
Okay, I have a couple of more comments, but I'm going to defer to my colleagues for any questions before I make those comments. Mr. Tillis, any questions? Ms. Prater?
Not really. I realized during the interview, the time you got most passionate was when Ms. Renata was talking to you about the STAR program and all the good that was, and you became a different person describing that. And
Because I love it.
Yes, sir, I can tell. And you've done some good work there. I want to congratulate you on that.
Thank you. I done helped so many men. I never thought I can do that. But the way I used to go to Ron Hicks and ask for help and he would help me, now I'm in his shoes to where you got a lot of men coming to me. Now I can help you. I can talk to you because I done been where you at. And now I can help you get to this point now. So I always tell them, man, come on, man, talk to me. I always was good at talking to people. Always.
I can tell.
Yeah.
All
I never,
Let us
I
talk.
never,
Hold on.
all right.
Didn't mean to start all that.
So, Mr. Fuller, I'm about ready to vote, but I wanted to make you aware of a couple of things. In
Yes,
the
ma'am.
record, we do have a letter from Mr. Willie Graham's daughter. This is what she has said. Her name is Tatiana Graham. Ms. Graham is unopposed to early release. She said, I believe he has served enough time on this crime. I love and miss my dad, but he has been gone for 30 years, and this guy was a kid when he shot him. I hope that he has learned his lesson and become a better person and will make something good out of his life if he gets out. How do you feel about that? All right, I understand. And so there's one other letter we have, and I feel compelled that I have to at least state it for the record. And this is from the state representative from District 4, that's Joy Walters. And she's written a very nice letter in support, saying that she believes, and this is just paraphrasing in part, she believes in a justice system that not only holds individuals accountable, but also recognizes growth, rehabilitation, and the capacity for change. And I think we see that in you. So I'm ready to vote. Mr. Fuller, my vote today will be to grant your parole based on your work, the comments by the warden, the support that you have, and particularly that of the Parole Project. I think it's very important that if you are successful today, you don't go back to Caddo Parish. I know your sister or somebody said they wanted to take you to be baptized there. That's something that can be happening in the Baton Rouge area. And then when you finish with their programming, because they'll have some programming for you, I would require community service work, at least 8 hours a quarter, and that is to speak to at-risk youth.
Yes, ma'am. I would love to do that.
All right, I'm just one vote. Mr. Tillis.
I concur with Ms. Renata.
Mr. Prater.
Okay, this is a very difficult job, but somebody that with your behavior and your all the positives, you make it less difficult for us to make decisions. Because of your age at the time of the crime, because of the support from your family, the Parole Project's willingness to be involved, your behavior while you've been incarcerated, the victim letter, and the passion you've shown during your interview, my vote also is to grant this.
Your parole's been granted. Mr. Fuller, good luck.
Hands at the pockets.
All right, and counsel?
Hello, Your Honor, John Gold, Block P 30758 on behalf of Mr. Hernandez. Please put your name on the record.
Okay, and good morning. Please keep your hands out of your pockets. Today is the date scheduled for show cause on this matter. Your client was ordered to pay fines and costs, and it appears as though he paid so he was ordered to pay $4,605 for fines and costs on his 3 misdemeanor convictions and 2 civil infractions. And it appears as though he still owes $4,313.20. So if I had to guess, there was a bond posted that was applied and your client didn't make any other payments. But I could be wrong.
I understand that, Charlie.
So, Mr. Hernandez, have you made any payments?
I think the last payment I made was October or something like that.
First of all, sir, we have to be able to record what you're saying. So then you need to make sure you're keeping your volume up, okay?
Okay. The last payment I think I made was October
October what?
last year.
Of 25? How much did you pay?
Like 50 or something. 50.
Okay, and was that as a result of getting your notice for the show cause hearing? Please keep your hands out of your pocket, sir.
What was the question?
Was that because you received a notice for the show cause hearing?
Well, I believe, and I could be wrong, that when he was here previously, because he's not on probation, that there was a payment plan entered. And I believe he made one payment of $50. That's what he informed me. But since that time, he's made no payments. And
Well, who was he placed on a payment plan with? Because
the docket is not very clear.
well, what's clear is that your client was on probation
Correct.
and he was discharged from probation January 9th of 2025.
Correct.
It appears as though he was discharged from probation but not having made a payment. But I'm going to,
That's,
Autumn, is it possible you can pull up GIS to see?
and that's what he indicated to
Okay,
me.
hold on 1 second, Council.
There was things in early on, Jay would increase the state date or something.
I'm looking to see if there are any notes in the computer that indicate a payment plan and what that payment plan was.
It was paying like 50 a month that started what it looked like.
Okay, when was the last, before October, yes, I see $50 per month beginning December 1st of 23. How many of those did he make?
My payments of 50, he made $100 payment. $85 payment, so 24, another $50 payment. That was like something. October 24, another $50 payment. 9 of 25 is $35. That was it.
Okay. So, sir, thank you. If you were unable to continue with your $50 payment a month, did you communicate into the court asking for a different payment arrangement?
No, I didn't.
Okay. So what's your proposal?
I can make a payment tomorrow, then I would like to, if you can, on the $50 payment, I can say payments this time around.
Well, okay, you're saying continue paying it, but you really weren't paying it to begin with, so it's not really continuing. You're asking to resume it?
That's correct, John. Yeah, correct. He was going through a number of problems financially, not himself so much as his mother. He was required, he had to help his mother out, ended up paying all of the taxes on home, as well as assisting her in other areas. At least that's what he's relayed to me. He understands he should have called the court and told him, hey, I need some more time or to pay this money. I know I owe it to you.
Right, I mean, we would have worked with you, sir, right? And I can appreciate that you're helping your mom out but then that's to your own detriment
Right.
because you didn't communicate that to the court. So how much you paying? You don't have anything to pay today.
I can pay, tomorrow. I don't have nothing right now.
All right, where are you working, sir?
It's called Hellingsworth. They do, car parts for Ford.
And so you're paying $50 tomorrow, and then it'll be $50 every month after that?
Yes, ma'am. Yes, Your Honor.
All right, are you getting a tax refund?
I haven't done my taxes yet.
Okay, are you do you typically get a tax refund, sir?
Yeah.
Yes?
Yes.
Okay, so can you commit to a portion of that to pay on this? It's a pretty significant balance. That's why I'm asking that, sir.
Yes, yeah.
All right, and so how much do you want to commit?
300. That.
Okay, all right. Okay, so then what we will do then, sir, is we will hold the show cause and abeyance. And it will be back on the docket if you miss a payment.
Okay.
Okay? If you'd like, sir, you can stop at the window and you can get information about paying it online. So then you don't have to worry about coming up this way if you're working or something.
Okay. Thank you, Your Honor.
All right?
Thank you, Your Honor.
You're welcome. Have a good day. We are on the record in the matter of the City of Wyandotte for Stephen Maritho, 251570.
Good morning, Your Honor. Edward Sutherland, appearing on behalf of the defendant, Mr. Maritho. Please try to sit still. Speak clearly for the judge. Give your name, sir.
But you have to unmute first.
Oh, you got to unmute first, sir. Ladies not a pilot, Your Honor.
Stephen Maritho.
Okay, and good morning.
Good
And
morning.
so, but it does not look as though your client's at the airport. I think he still might be at work, but I'm not sure, unless he works at the airport. I don't know. Oh, no,
Yes,
he works
I am.
he works for an airlines or something, right? You said?
Yes, American Airlines.
Okay, so, Mr. Maritho is on Zoom because he's stuck out of state for work purposes. Mr. Zelnak was at court yesterday on behalf of Mr. Maritho. And, Mr. Maritho was expected back yesterday. However, due to, weather issues, Mr. Maritho was stuck in North Carolina, correct, counsel?
Yes, Your Honor. He's actually stationed at that airport for American Airlines. He said there's more flights and more work. He's originally in Detroit. They moved him. So he commutes from Detroit to Charlotte every week and comes back home.
Okay, so let me also state that I do know your client. I haven't really seen him or otherwise. He did send a message asking if somebody misses a court date or they're out of town, how does that work? That was before you were here yesterday. But that's about the only communication I think I've had with your client in the last couple of years.
I don't have a problem with this court hearing the case. I know it's been some time, and I know that the court's fair. And Mr. Maritho, I don't have a problem with Judge DiSanto hearing this case. Do you?
No, not at all.
But one thing I want to make clear, Mr. Maritho, we may have had children on the same team, coached the same teams, things like that. During the pendency of this case, you're not to communicate with the court's relatives by text or any other message or method. You go through your counsel. Does that make sense to you?
100%. Yes, sir.
Judge, I'm sorry that happened. That's before he spoke with me, so that would have never happened.
Okay.
And we'll waive the reading. Ask court stand in mute, enter a plea not guilty, and set a pretrial date. And I'd like to do it next Wednesday because we've got a plea offer. Can you be here next week from work, Mr. Maritho, for Wednesday for court?
I will try and do what I can. The next Wednesday, is there, yeah, if that's what I need to, I mean, a little bit more of a notice would be easier.
Let me ask this question. So the only day that the Wyandotte prosecutor is at the 27th District Court is on Wednesdays. What is your work schedule? And are you at work? Do you work during the week out of
Yes.
state?
Typically, as of right now, there's a new bid coming out, but my bid right now, I have Friday and Saturday off.
Okay, So counsel, I'm not going to put your client's employment in jeopardy. There are many individuals that are out of state for work. We will allow your client to Zoom in. He doesn't have to somehow make his way back for Wednesday and then go back to work. So we will allow your client to appear via Zoom for his pretrial.
There should be a plea in the file. I would do it today, but you know how I let people be here in person, so.
Well,
And I know, and I appreciate you extending that courtesy.
so we will
Thank-
schedule
yes,
this
thank
for
you.
February, you're welcome, February 11th at,
I'm here 8:30.
well, I guess we'll just do 8:30. Does that work? Okay. Whatever you say. Okay, so 8:30 a.m. as to bond.
We can't post a cash bond. They had asked for substantial.
Actually, you did post a cash bound
We
already
did, okay.
on November 13th.
Oh, yeah.
25.
Take it on.
Okay,
Been a delayed complaint. How did it get so far in the middle? Because I found out about 3 weeks ago, Mr. Morito. Seems to be more.
well, no, so the offense date was November 7th. Let me see here. Then it was set on the docket and mailed out November 18th for today's date.
All right.
Well, actually for yesterday's date.
Judge, then, I thought it was like Spirit never notifying you when the flights are canceled. I just wanted to know if there was some communication issue. So, Your Honor, I'd ask you to continue that bond, usual conditions, no drugs, alcohol, no drinking, no illicit narcotics, and when he comes in, I'll have him list what prescription drugs he's on, who's on any.
All right, and so Mr. Morito, if you were to test right now, what's in your system?
Nothing, ma'am.
All right, and I do show that in 2023, there was a matter, counsel, and I believe that I disqualified on that matter. But that was, I believe, well, that was because our children were still in school together and they're not, they've graduated. So I just wanted to just state that for the record.
I have no problem with that. Thank you, Your Honor.
Are you randomly tested for work purposes, Mr. Morito?
Yes,
And how long have you been working at your current employer?
just, it'll be 2 years in May, ma'am.
All right. All right, the court's going to, if I didn't already indicate, you not to possess or consume any alcohol or drugs unless prescribed. And I'm going to also order random testing. So I need you to email into probation and then they will communicate with you how to set up the random testing. So you can, I will also make a note that defendant works out of state Monday through Friday. And we'll need to locate testing facilities. So you'll have to just communicate with probation, sir, regarding the testing out of state. All right, so email into probation by 10:30.
Judge, I'll walk over to get the probation email from him and I'll text it to him.
Okay, very
Thank you,
good.
Judge.
Thank you. Have a good day.
Okay, folks, just a reminder, as I said earlier, as we enter the fourth hour today is just going to be more court. Again, I have a crew here working on some stuff at the bunker, and I keep getting pulled away, so it's not a good hour for me to try to do any kind of discussion or commentary because it'll just get interrupted. So let's continue with Judge DiSanto for a little bit.
Okay. And counsel, today's the date scheduled for the probable cause conference, and there's a request for another adjournment.
Right. We've requested certain discovery from the prosecutor's office. They've not produced it. They were going to follow up with their officer in charge. That's what I understand from our conversation.
All right, well, let's see, January 15th, we adjourned this so that council could review discovery. We adjourned it to January 22nd. January 22nd, the PCC was held and indicates defense did not receive digital discovery. And now here we are 2 weeks later and you still don't have that?
No, I don't. The discovery, I mean, I sent a list 2 weeks ago of everything that was missing.
So council, when did you follow up?
Well, I followed up the day of our last court hearing with an email.
Was there any follow-up last week?
Oh, let me do a search. I definitely. Yes.
Bobby, can you please grab Mr.
Yes. Well, let's see. January 22nd was our last court date. So another one. Let me see here. February 3rd.
I've sent a few emails.
Good morning, council.
Good
Will you
morning.
please place your appearance on the record?
Good morning, Your Honor. Mohammed Mahabu.
Okay, so this is regarding Miss Ariana Brown Jones. So Mr. Godwin, you indicated that you, on February 3rd, you sent a follow-up 2 days before the court date?
Yeah, another follow-up then, yes.
There wasn't any follow-up last week or the week before?
Well, there was a
Well, the 22nd.
email. Yeah, that's
Okay.
correct, Judge.
Mr. Mohammed, why has the discovery not been sent over to Mr. Godwin? This is now the third request for
Yes.
adjournment for discovery purposes.
So, Judge, we did send 2 requests now to the OIC. I think the OIC on this case was on vacation, if I recall correctly.
He's on vacation this week.
Oh, he is?
Yeah.
I know last week he was as well because he had a case last week that involved him, and I wanted to turn over restitution to him. It's that co-defendant case we had with restitution, and he was not available on that day. So I think he's just unavailable right now.
Okay, but doesn't the detective upload the discovery onto evidence.com when they submit their warrant request?
Yes, so that discovery was sent to the defense. It's the digital that the defense is missing.
So they don't, so the police
discovery
department,
packet is
the police departments don't upload digital discovery, only the paper discovery?
They're supposed to, but they didn't on this specific case. And so I sent an email, I think last week, to OIC informing them we're missing digital, can you please upload? And then I sent a follow-up email, and we still don't have it. So we're just asking for a 1-week adjournment. There's a stipulation with the defense, my understanding. And I think it will be resolved. And if it's not resolved, if I don't hear back by the end of the week, I'll reach out to another detective. But
Well, or there can be some communication upstairs with a detective right now, because here's the problem, right? So now this matter has been pending, it's a month, and there was 1 request to adjourn on January 15th so that defense could review discovery. January 22nd, defendants did not have all digital discovery, so we adjourned it to today, and now it's a request for an adjournment for the exact same reason, 2 weeks later.
And Judge, we're prepared to move forward to the preliminary exam. I understand defense may want to review that, but we are prepared to move forward. Discovery is an ongoing process, so I think we can move forward for purposes of the exam. But I don't have any objection if defense wants to adjourn. However, I understand the court's position.
Have you been able to go upstairs to see when Detective Carr is back to make sure you're going to get this information before next week?
No, I did not go upstairs, but I can. And I'm sure other detectives may have access to the digital to ensure it's uploaded.
This is the final adjournment.
Thank you.
February 12th. What time works, Ally? Autumn, sorry. 10 a.m. 10 a.m. Does that work for you, council?
Sorry, 10 a.m. Okay, sorry, Judge. Let me see the time. I have an exam at 10 a.m. next week. I could do 11 or earlier.
Does 9 a.m. work for us?
We can do 8:45.
Does 8:45 work for you, council?
Yeah, yes, that would work. Yes.
In Oxford County, we're taking up 2 files. Each file is entitled People of the State of Michigan versus Nathan Douglas O'Brien. 2 case numbers are 25-13990FH and 25-13991FH. Appearances from council, please.
Nate Carnes on behalf of the people. Phil Burdett on behalf of Mr. O'Brien.
Thank you. Before the court also is Mr. Kevin Stubbleman. He's an agent from the Michigan Department of Corrections, who is here today serving as the probation officer. And joining us this morning from the Wexford County Jail is the defendant, Mr. Nathan Douglas O'Brien. Mr. O'Brien, are you able to see and hear the court today, sir?
Yes, Your Honor.
All right, thank you very much. Just a minute, catch up on some paperwork here. We're here today to address a request and summons for a probation violation that was filed back on October 15th of 2025. It included 2 allegations, both having to do with allegations involving failing to comply with the Sex Offender Registration Act here in the state of Michigan. And it was released on a personal recognizance bond, like on November 6th. The matter was set for an informal hearing initially on November 14th of 2025. And that was appointed to assist. Were you appointed or retained?
I was appointed, Your Honor.
All right, thank you. We also appeared on that 14th, and the parties each waived their 14-day rule underneath 6.445. And the court therefore had it set for a hearing. It was initially set for December 8th of 2025. And then it was reset after that for today's date. And that's why we're here. Mr. Carnes, you know what we're doing today?
Your Honor, I think defendant will be pleading guilty. The people have agreed to recommend time served and continue probation.
Did he pick up a charge? I'm sorry, did he get a conviction related to this?
Your Honor, he's going to be arraigned on that today at 1:30. I have made an offer to Mr. Burdett on that file, although he's not technically his appointed attorney on that file.
And why is what's he in jail for?
Your Honor, he was picked up on the new charges, and I didn't know.
Okay.
I was been always in jail, so I didn't have a chance to talk to him about it.
All right, have you had the opportunity to speak with him today?
No, I didn't, Your Honor, and I'm going to be requested to be appointed on his new case, so we
All
can
right.
wrap that up then.
So we can do a couple things. Let's assume for the purposes of this next part that he ends up entering a plea guilty to 1 or more of these violations. The court could then I can give him time served, but does he really want a sentence today, or do you want to wait to find out what happens on the other case? I don't care.
This is his first SOAR violation. The offer downstairs is for Killebrew to find the cost and this.
Okay, so theoretically, so we could also do this, Mr. Burdette. We can take a couple minutes and allow you some time to go into another room. Do you have a computer with you or?
Yes, I do, Your Honor.
All right. Our next matter currently scheduled at 9:45, thus we have some time. And that is just a pre-trial and a show cause. So what we're going to do is we're going to take a recess here in place, allow you to use one of the other rooms, call into the Zoom. Do you have the Zoom number?
No, I don't, Your Honor.
All right. Mr. O'Brien, what we're going to do is make sure you have the opportunity here in a moment to speak with your counsel. Mr. Burdette's going to go into another room. He'll dial into the Zoom account, and then we will place the two of you into a private breakout room. And he'll come back and let us know when you're ready to go on the record if we're going to do so. You understand?
Yes, sir.
All right. Thank you very much. We are.
I don't understand. I do understand that, but.
All right, well, they rack up the next contestant, I guess. There is a new contestant in front of the board. Let's go back there.
Parole is signing in at Orleans Justice Center for revocation proceedings. Today is Thursday, February 5th, 2026, and it's 10:12 a.m. And our first case this morning is Mr. Green. Good morning, sir.
Good morning, ma'am.
Would you introduce yourself? Tell us your name and DOC number.
My name is Brandon Green, DOC number 493822.
All right, sir, thank you. And you have counsel with you this morning. Mr. Boucher, would you introduce yourself, please?
May it please the board, Kevin Boucher, bar number 03286, representing Mr. Brandon Green.
Thank you, sir. And we also have Mr. Green's sister, LaKaiser Green, and she wants to speak. And we'll ask for her remarks shortly. Your case this morning, Mr. Green, has been assigned to Mr. Tillis, so I'll turn it over to him.
Good morning, Mr. Green. How are you?
Good morning, sir. I'm all right. How about yourself?
All right, I'm going to read some violations and you can plead guilty, not guilty, or with a statement. Violation number 4, you failed to restrain from criminal activities. You were arrested on April 8, 2025, Orleans Parish Sheriff's Office. You were charged with possession of a firearm or weapon by a felon and possession of marijuana. The charges are of possession of marijuana less than 14 grams and possession of a firearm weapon by a felon were accepted by the district attorney's office. The charges are set for pretrial conference on 12/9/2025 and trial on 1/20/2026. The subject was found not guilty of possession of a firearm or weapon by a felon. The subject was scheduled for a bench trial on January 26, 26 for possession of marijuana, THC, and chemicals, subject by the schedule, under 14 grams and an unsafe vehicle violation. The trial has been reset for January 28, 2026. How do you plead? Guilty, not guilty, or with the statement?
Not guilty, sir.
Okay, Mr. Kevin, do you want to elaborate on that?
Certainly. Ms. Lakeisha Green who's present on Zoom today, will testify, as she testified before the jury of 12 citizens, that she was responsible for placing the firearm in question, that Mr. Green had no knowledge of the firearm. No DNA was found in connection with the firearm to be tied to Mr. Green. And perhaps most importantly, ladies and gentlemen of the board, 12 citizens heard this case and found Mr. Green not guilty in 55 minutes.
Thank you, sir. Rule number 5. You fail to refrain from possessing a firearm as evident by your arrest on 4/8/2025, which you were charged with possession of a firearm or a weapon by a felon. How do you plead, Mr. Green? Mr. Green, did you hear me?
Yes, sir. Not guilty, sir.
Not guilty with a statement?
With the permission of the board, we would incorporate the same statement we just delivered in connection with the previous violation allegation.
Thank you. That's what I thought. Rule number 10, violation number 10. You are in the arrear of $4,725 plus the $65 processing fee. No payment was ever paid as instructed. How do you plead?
I plead guilty, sir.
Okay. I guess at this time, we'd like to hear from your sister by Zoom. Ms. Green?
Good morning.
Lakeisha, tell the board exactly what you told the jury 2 weeks ago.
Okay. The weapon was actually placed in a car by me. It was actually an ex-boyfriend weapon. I was actually returning it to him. I was on my way to go get my hair fixed. I was actually returning it to him. Went to the residence where he was living at. The house was abandoned. He no longer lived there. So I still had possession of the weapon when I went to Brandon's girlfriend's house to get my hair fixed. He actually came in and asked me to use the car. Put in mind, this is my mother's vehicle. We all use the car. He asked me to use the vehicle. Me being distracted, like I said, when I actually got to the house, I actually shoved the gun on the side of the seat, like pushed it all the way under because my mother doesn't have tinted windows. And because the car was parked on the street, I didn't want nobody to see the weapon and break into the car trying to get the weapon. So I shoved it like on the side of the driver's seat, like pushed my hand all the way down and pushed it down. Brandon actually came in around 2, little after 2, and asked to use the car to go get something to eat. I actually gave him the keys, slipped my mind playing in my phone, forgot the gun was actually in the car. I didn't find out that Brandon went to jail until my mama called me. So the gun was actually placed. He had no knowledge. Nobody would have never known that the gun was in there just by getting in the car. You would actually have to search the car in order to, the way I had it shoved, you would actually have to search the car in order to know that a gun was in there. It wasn't visible, so he would have never known or had no idea that it was in there.
Ms. Lakeisha, is that what you told the jury under oath before Judge Pittman on the 21st of January?
Yes, sir.
And is what you're telling this board, as you told that jury, the truth, the whole truth, and nothing but the truth?
Yes, sir.
Listen to the board. They're going to have some questions for you.
Okay.
Any of the members have any questions for her?
Oh, I don't have any questions of Miss Green.
Okay, thank you, Ms. Green.
Thank you.
Does she have permission to sign off, ladies and gentlemen of the board? Because she wants to go to work at Dollar General.
Yes. Thank you.
Thank you. Thank you, Ms. Green.
Mr. Green, what about the drugs that you have? Are you on drugs? You're using drugs?
Sir, the drugs was actually, I didn't have a lot, but I spoke with my parole officer, Miss Virginia, and she recommended me to get the dispensary card for marijuana, which is on my file. Everything should be in my file for marijuana, but any other drugs, no, sir.
The marijuana in question, ladies and gentlemen of the board, was found inside of a registration form. Ms. Green has indicated the fact that multiple people used the vehicle. It was approximately 1 maybe 1 inch worth of a partial cigarette. It was not a large quantity of marijuana, and that matter is presently set for trial.
Board members have any questions?
I didn't understand what you said about the card. Mr. Green.
Ma'am, is speaking to me?
Yeah, could you tell us again what you said you were advised by your parole officer about the card?
No, not about the car. This is way before the car incident. Miss Virginia, who was my parole officer before Miss Tiffany Jones, she had told me that I was dealing with a herniated disc in my back, and she was like, "Well, you can get a medical card for marijuana, and you know, if you want to use marijuana, you can use marijuana, but you got to get a medical card." So I went and got a medical card for the marijuana, but the marijuana that was in the vehicle, I didn't have any knowledge that the marijuana was in that vehicle at all. That marijuana didn't belong to me at all, man.
Okay. Well, let me just advise you that the use of prescription marijuana has to be approved by the board,
That's important.
not by the officer, just FYI.
That's important.
Okay.
Yeah. Okay. That's all.
You're gonna have to convince me about the gun, because the state trooper says the gun was in plain view, that he could see the extended clip and all of the extended clip portion of the gun, which was a 20 shot extended clip, above the driver's seat. Explain to me how that reconciles with what your sister just said.
If I may, Mr. Board Member, sir, I'm trying to read your name, sir, correctly. I want to pronounce it. Prater, Mr. Prater, thank you, sir. The bottom line is that there was no physical photographs showing that aspect of the weapon. More importantly, I asked specifically about whether or not that gun was tested at all. But they ran a test for DNA on him, but nobody bothered to tie anything at all with respect to the firearm. The clip, there's no photograph of that clip being shown as being visible. That's what I'm trying to drive at, sir. And the evidence that was produced at trial, and again, it wasn't like the jury deliberated very long on this. I just think that needs to be considered.
Consider it.
Any other questions?
I know. Ready to vote.
Ready to vote, Mr. Tillman?
Today, my vote's going to be in violation number 4, possession of marijuana. And my vote will be to revoke your parole.
Mr. Prater?
I concur, and I think the gun, it's a he said, she said thing, and I believe that the state trooper saw it. The fact that the DNA, that's irrelevant since it wasn't tested. Revoke it.
All right, and I do agree, Mr. Green. My vote also today is to revoke for the violation of condition number 4. Today, sir, your parole's being revoked. Good luck to you, sir.
Denied. So Lindsay puts in the chat, if everyone is sharing this car, maybe don't leave the guns and the drugs in there. Yeah, but where's the fun in that, Lindsay? I mean, you know, if you're going to have guns and you're going to have drugs, you ought to just leave them out for everybody. I'm just saying. You know, maybe it's just me. Anywho, let's go back to Judge Elmore, because the contestant that we saw earlier is back, it looks like.
Court recessed in place. Are present again. Mr. Burdette, how would the defense like to handle this today? Either set it aside, do a plea, it doesn't matter, I just want to.
My client's gonna be entering a plea today.
Okay.
Pursuant to the agreement, it's just gonna be fines and costs. And then I'll make myself available this afternoon to zoom in down in district court to resolve that.
Thank you.
Mr. Carnes, does that sound accurate or what you understood we're doing?
Yes, sir.
All right. Mr. O'Brien, I'm now going to turn to you. Can you still see and hear me?
Yes, sir.
Thank you. Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide to this court will be the truth, whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. All right, Mr. O'Brien, I'm going to go over this again with you as it's been a few months. You are currently charged on a piece of paper that's called a request and summons for a probation violation. On that, you are alleged to have violated your probation terms and conditions in 2 ways. Count 1 alleges that you violated special condition 4.22. That condition requires you to comply with the instructions of your field agent. And more specifically, it's alleged that on September 30th of 2025, you had failed to comply with a written order from your field agent to verify your registration underneath the Michigan Sex Offender Registration Act. That is what's called a technical violation, and I'll explain to you what that means in just a moment. Count 2 alleges that you violated condition 1. That condition of your probation requires that you are not to violate any criminal law of any unit of government. And again, it's more specifically alleged that on or about September 30th of 2025, you had violated Michigan law by failing to register with local law enforcement as required under the Michigan Sex Offender Registration Act. That one is called a non-technical violation. When there are technical violations, such as count 1, the court is required to, limited to any sentence or additional punishment to a sliding scale. For 1 count, it's for one technical, it's up to 15 days. The 2 technicals, it's up to 30 days. For 3 technicals, it's up to 45 days. For 4 or more, the court would no longer be limited to that sliding scale and would only be limited by the amount under the law. Similarly, for a non-technical, such as count 2, the court is not limited to a sliding scale and is only limited to the amount allowed under the law. So far, do you understand?
Yes, sir.
In this file, you originally were convicted of assault, resist, obstruct a police officer. That is a felony punishable by up to 2 years and or up to $2,000. Therefore, it's a felony. Therefore, that sliding scale is the one I mentioned. Now, there's also another interesting quirk here is when a single act is alleged and could support 2 probation violations, the court would treat them as 1 because they are what's called the same transaction of events. In this instance, while it's listed as 2 counts, I'm required to treat them as 1 count. And it's a bit silly because no matter what, they're treated as non-technical, which means the sliding scale that I mentioned earlier would not apply. Now, if you plead guilty to these actions, allegations, you will not have a hearing or a contested hearing today, and the prosecutor, you would be waiving the right to have the prosecutor prove the allegations by a preponderance of the evidence, the right to question, cross-examine the evidence against you or witnesses against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. And of course, you'd be waiving the right to remain silent and not have that silence used against you. Do you understand that, Mr. O'Brien?
Yes, I do.
Now, there's another factor I want to make sure I cover, and I have no reason to think that there's any deception being played here by the prosecutor between he and Mr. Burdett and you. But if you make an admission here in a couple minutes, that could be used against you in the other case, which I'm told you're going to appear for an arraignment today. Any admission right now could be used against you in the other one, so therefore you'd be found guilty, if that makes sense. But I'm told today that you, through Mr. Burdett, with the prosecutor, have reached an agreement that will resolve that case today as well. And as I understand it, the sentence agreement would be that you would only receive fines and costs. Is that what you understood?
Yes, sir.
Knowing all that, do you still wish to enter this plea here today that we've already talked about?
Yes.
Again, actually, I didn't say it, but I understand you're going to plead guilty to these 2 counts. Now, there's also some discussion here between the counsel.
Uh, 2 days then, 2 days. This will be the second day.
Okay. Yep, all right, good, thank you. Mr. Stapleton, is that what you understand is going to go on and you're going to make that kind of recommendation?
Yes, sir.
All right. Have there been any other probation violations involving Mr. O'Brien in these 2 files?
No, Your Honor.
Oh, Mr. O'Brien, it was my failure. I forgot to make a note here. And I told you what the conviction was in file 13990, but I forgot to tell you what it was in 13991. 1 second here. Oh, well, this is a little more interesting. In the other file, 13991, you were convicted of a misdemeanor of larceny with the value of at least $200, but less than $1,000. Now, because that's a misdemeanor, and this is why I said it's a bit more interesting, in that file, when there's a misdemeanor, the court's limited to a sliding scale of 5 days, 10 days, or 15 days for your first, second, or third technical violation. But because there is a non-technical, it wouldn't be limited to that sliding scale. But it's my understanding that in both of these files, there's an agreement between you, through Mr. Burdett, and the prosecutor that there wouldn't be any additional jail. Is that what you understood?
Yes, sir.
Is that how you wish to resolve these 2 probation violations?
Pleading guilty.
All right, thank you. So, even though you said that's what you're going to do, I have to actually ask you. So here we go. As to the 2 counts of probation violations that appear in both of these 2 files, how do you plead, sir?
Guilty.
All right, thank you. One moment. The file. The court takes judicial notice of the terms and conditions of probation that appear inside each of the court files. They were signed by me on June 9th of 2025 and subsequently acknowledged by the defendant. They were both dated the same date. All right. Mr. O'Brien, is it true that you had to register as a sex offender either through these cases or through some other case?
Yes.
And is it true that your probation officer told you that you needed to go get this done?
Yes.
And is it true that you failed to get it done in a time frame he told you to get it done, which means you didn't report to local law enforcement, such as the Michigan State Police Post here in Wexford County?
Yes.
Mr. Carnes, do you believe you provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements?
No, Your Honor.
Do you believe that thus far I'm in compliance with the court rules?
Yes, Your Honor.
Mr. Burdett, do you agree with all 3?
Yes, sir.
Thank you. Are we able to proceed to sentencing, Mr. Carnes?
Yes, Your Honor.
Mr. Stuppleman?
Yes, sir.
Mr. Burdett?
Yes, sir.
All right, I need to, before we turn to sentencing, Mr. O'Brien, I need to advise you that you have the right to be physically present in the courtroom when I give a sentence. That's how it works in every case. However, if you're willing to, you can waive that right and allow me to conduct sentencing right now. Do you waive that right to be physically present and therefore allow me to use the video technology?
I do waive that right.
Mr. Burdett, any objection?
No, sir.
I find pursuant to the Michigan court rules that it's appropriate to use the technology, and I turn now to Mr. Stapleton. Sir, your recommendation?
Thank you, Your Honor. The defendant was originally sentenced June 9th, 2025. 2 two dockets. The original sentencing guidelines were 0 to 17 months. He's done well and is actually in compliance now. He's I've not had any problems with defendant at all. I recommend defendant be sentenced to 136 days jail with credit for 136 days and probation be continued and fines and costs preserved.
Carnes?
Thank you, Your Honor. This does appear to be the defendant's first SORA violation. I do take that seriously, but I also understand sometimes. Oh, I hope this is it, because obviously it gets. I will push harder on future violations, but it is good to hear that Mr. O'Brien is doing well on probation. I think it's a reasonable resolution today, so I'd ask the court to go along with it and impose time certain. Thank you.
Mr. Burdette?
Yes, Your Honor, I agree with the prosecutor. My client has fully registered with SORA. He's done well on probation, so we're just requesting you follow the recommendation this time.
Mr. O'Brien, is there anything you wish to say before I issue a sentence on these violations today, sir?
No.
All right, thank you. All right, well, I trust today the advice and comments from Mr. Stapleton. He normally is very open about probation performance by probationers underneath his supervision. And I accept that here today. I can say that other than this, I haven't seen Mr. O'Brien for the court. And again, sometimes I understand that it's interesting in the state of Michigan. There are differences of opinions, even within the Court of Appeals, Supreme Court, about whether or not SORA is a punishment or not a punishment. But I think it definitely has that impact, and it requires a person to go out and register. And sometimes doing that can be difficult, but he's overcome that through the guidance of the counsel and the probation department, and he's now therefore in compliance. And there hasn't been any other violation, which is really quite important here, as I don't have an allegation of a new crime here before the court. So therefore, the court will accept the recommendations from the probation department. I think technically what I have to do is 1, preserve fines and costs, 2, continue probation as previously set by this court, and 3, I think I have to give 137 days with 137 days of credit to count yesterday and today. So therefore, that's the sentence of the court. All right. Mr. O'Brien, the next thing that's going to happen is in each one of these files, you're going to get 2 copies of a document. Now, you've already had this document before, but I have to give them to you again. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal, which only happens when someone's been convicted by a trial or at a trial by a judge or a jury. Because of the police in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want me to approve the appointment of an attorney, you may complete the bottom half of one of these documents and return it for each file and return to the court within 42 days. Now, again, I told you that you're getting 2 copies in each file. The first one, you're actually just going to put your initials on. Doing so neither elects nor waives any rights. It merely acknowledges receipt of the other copy. The other copy is for you to take and then return to me if you want me to appoint an appellate attorney, or it's for you to either put into a recycle bin or trash or burn or in an appropriate receptacle. I don't need it back if you don't want an attorney. Okay?
All right.
You have any questions, Mr. O'Brien, about what we have done today?
Not at the moment, sir.
All right, good. Well, right now is the last moment I'm going to see you. So, all right, well, I'm done with you. Anything further, Mr. Burdette?
No, Your Honor. Nate, I'll see you this afternoon.
All right.
Okay, thank you.
Is he on, so he's been arrested for the other charge, right?
Yes, Your Honor. He's going to be arraigned today. I'm going to see if I can appear by Zoom at 1:30.
Okay.
Get an appearance, and then we can wrap it up today.
All right, no problem. Anything else, Mr. Carnes?
No, Your Honor, thank you.
Anything else, Mr. Stuppleman?
No, Your Honor, thank you.
All right, folks, thank you very
Thank
much.
you,
We are adjourned. This case number 5-14153-FH. Appearances from counsel, please.
Lisa Dole for the people.
And I'm Jeff Harrison. I'm here on behalf of Devin Jean Plum.
All right, thank you. Ms. Plum joins us this morning from Wexford County Jail via Zoom. Ms. Plum, are you able to see and hear the court today?
Yes, I am, Your Honor.
Thank you. We are here today for a motion filed by the defense regarding a modification of bond. The court has received and reviewed both that motion in writing and a response submitted by the people. Mr. Harrison, the floor is yours.
Well, Your Honor, in a lot of ways, this is a relatively, I suppose there's no such thing as a formulaic or regular type of motion. This is a motion that was contemplated by the parties and discussed a little bit by the court in our last proceeding in court, to the extent that Mrs. Carey also said, go ahead and file your motion, but I'm going to oppose it. So nothing that's happened so far has come as a surprise in any way. The court intimated to Ms. Plum the last time we were here that you would at least be open to the idea of her receiving residential treatment. And frankly, the court also stated that it wasn't a problem if she wanted to go before her scheduled hearing date. In response to that, Devin has been able to, working with Brian from our office, arrange an intake appointment on February 17th at a residential treatment facility. I don't like to say that it's a form motion, Your Honor, but it contains language that the court has requested we include in such motions. As far as the transportation issue and who's going to monitor what and that sort of thing. I'll be happy to take more questions, but I don't have a whole lot more to argue than what's in front of you guys. Thank you.
All right, thank you. Ms. Dahl, on behalf of the people. And again, I've reviewed even this morning your response. So.
Thank you, Your Honor. Just to reiterate that Ms. Blum has a drug problem, and that's clear from her record. In the police report, she stated that she just got out of rehab and was clean at the drug house that she was found. There was a search warrant served on the drug house. There was a drug sale at that drug house and lots of drugs found in the house. So
Where was
I
that
thought
house? Okay.
in Harrietta.
Uh-huh.
Your Honor, just based on her statement, it's clear that she's not serious about getting treatment and getting sober. I also got some new information that while she's been in custody, she's made phone calls stating that she's ready to resume work with Ms. Keegan. So I believe that her.
Who's Ms.
Keegan? Ms. Keegan, the city.
Oh, hold on. I'm sorry.
To resume work, meaning with Ms. Keegan, the city, Ms. Keegan, I'm assuming drugs.
Oh, I'm sorry. I thought it wasn't Miss Keegan, but you said Muskegon. Okay, now I get it.
I apologize.
That's all right.
So I believe her intentions are not genuine. She's had multiple drug charges in the past where she had opportunities to get the treatment that she needs. I think at this point, she's trying to seek treatment in order to not get further jail time. I don't think she's serious about getting sober, as evidenced by her stating that she just got out of rehab and then immediately placed herself in a drug house. It is the people's objection that this be granted.
When was the alleged phone call or communication where she made that statement? When did that occur? Before or after the plea?
Your Honor, I am not sure. I got this information just this morning from Ms. Carey, so I don't have the details. If the court would like, we can postpone this hearing to another date and I can get more details from the jail.
All right. So part of my reason for asking that question is well, and I'm not challenging, it's not up to the judge. Judges don't get to take a plea and then say, you know, yeah, I don't like that plea. I think it should be higher. I think it should be lower. Courts only get to apply their discretion when it comes to a time of sentencing. And if the people are so heavily concerned, they took what was a life offense down to a 2-year maximum. That would be on the government, not on the court. So I'm taking some of that with a grain of, well, lots of salt, because if she was that big of a drug dealer in Arietta, then I would anticipate that. And by the way, Ms. Plum, I'm not saying that. I'm just saying if that's what she was and that was the position of the people, you know, they just took a life offense down to a 2-year, which means they know that more than likely it's going to be an intermediate sanction cell. Means it's going to start with the presumption of no jail. But okay, Mr. Harrison.
I'm kind of taken aback by the prosecutor's stance in this matter. Assuming that the prosecutor is not a professional drug and alcohol counselor, someone who has already pre-screened her and said she's eligible and is a good candidate for the program. Not to mention, we also have a social worker who is a trained person as far as evaluating people with drug and alcohol dependency issues, and he's determined that she's an appropriate candidate for this situation. This would not be the first person in the history of mankind that had to go back to rehab. It happens. Unfortunately, it happens. And it happens because for a lot of the same reasons that Ms. Plum was trying to extricate herself from when this occurred. We all know
whose house?
It's Robin and Jeff Plum's house. It's a fairly notorious location.
I'm well aware of that.
She was not living there full time. In fact, she had returned there to retrieve some more of her belongings on that day when TNT paid them a visit. I think the majority of her issue is she gets out of rehab, she gets out of prison, she does have a determination to start a new life, but the only life she knows revolves around the methamphetamine use and trade. That's the cycle we're trying to break, and that's the help we're trying to get for her. As far as her getting less time in jail, I don't think that's even a consideration in this at this juncture. Devin has told me repeatedly that she wants to go to rehab, whether the court sends her or not. This looked to be a good juncture to get that to happen prior to the return, probably of adjourned or postponed sentencing, in which we could say to you, Judge, she completed another rehab while she was awaiting sentencing.
When was the last time she was in rehab?
It was a couple of years ago. I don't recall the exact date. Ms. Plum would know that.
Ms. Plum, when was the last time you attended any outpatient or inpatient treatment?
2023 through 24, when I was on parole, successfully completed. With Steve Saladay, Your Honor.
Okay.
But if you're asking residential, besides before I came here, I haven't been since 2010, 2012, I believe.
Yeah. Another 23.
All right. Well, when is sentencing scheduled for? Do we have a date, man?
Yeah, we do, Your Honor. Let me.
23rd of February?
Yes.
All right. Do we have a PSI already? Sometimes we get them done quickly.
We do not.
Oh, okay, thank you. All right. Well.
Your Honor, with all due respect, I just thought I'd let you know, Brian Potter did say he was trying to find out what happened today before he turned in the PSI. I seen him last week, just so you're aware. Sorry.
Thank you. It's okay. It's all right, Ms. Palmer. I appreciate you telling me. I'm not surprised. That would make sense. So. Well, I'm tempted here to make further comments about the whole situation. I will note that in my position, having been on both sides of the courtroom floor out there and having been up here now for over 5 years, that house, that location is well known. I know we had a case last year involving her father, and I don't hold that against her, but it does involve the same location, which even Mr. Harrison acknowledged. And I don't hold that against her. She's not responsible for the sins of the father, but the point here is she's been in this lifestyle, this world for a long time. And I also want to give credit. I also want to give as much help as I can when people are dealing with controlled substances. Now, I'm also very sensitive as a judge. I know that there was an appeal in that case and there was a court ruling. And what often is disappointing is the appellate courts don't always, or the attorneys for those cases don't always explore the full facts of the case. And by the way, Ms. Plum, do you know what I'm talking about, ma'am?
Yes, I do.
In that case, I stopped the trial, sent the jury out, and we had this conversation. What didn't get found out and put in the appellate record was we had a conversation in chambers where the attorney was warned, don't go down that road. And sure enough, that's what he chose to do. So when I say we all know what's going to happen, it was because we'd all talked about it in chambers. So I don't hold any of that against you either. So that's what I'm trying to be really sensitive to. None of that has any impact on my decision in here. And again, the sins of the mother and the father don't go over to the child. But I'm really concerned about you. Do I think you're in this world? Yes, obviously you are. Think you have a drug problem? Clearly you do. Do I want to see you stop it? Yes, not only for you, but the community. I think that drugs are the largest criminal problem we have in our county. I can tell you that it's not me being biased. I can tell you that's just statistics. So, but at the same time, I have the chance to send you to rehab and to give you the keys to the prison cell. Which means, because if I send you to this rehab program, which I'm going to do, and you flee, abscond, fail the program, then you'll only have yourself to blame. Does that make sense?
Yes, it does, Your Honor.
The court will grant the motion to modify the defendant's bond. And go back here and take a look at the language again for the court clerk.
Your Honor, may I say one more thing?
Yes, ma'am, of course.
I don't know if you're aware, but my mom did pass away in the beginning of December.
Oh.
So.
I'm sorry, I did not know that.
I assumed the court was
No,
aware
it's
that
okay.
Yeah.
Robin Plum passed away from an accidental intoxication of fentanyl.
Overdose.
See,
Yeah.
see, Devin,
But I'm gonna
that's,
use that, oh, go ahead.
no, I was gonna say, Devin, that's why I say drugs are not victimless crimes. They spill onto other people, they spill onto children. And, I know your mom had struggled. I've seen her here in the courtroom, and when I hear about that, it just makes me feel bad, like somehow we failed, or the system.
No, yeah.
So, I'm
I
very
just
sorry.
wanted to, I'm sorry, I don't mean to interrupt, but I just wanted you to know I think she gave her life so I could live mine, and that's how I'm gonna use that.
Well, I'm hoping so, Devin, and I don't mean to use your first name insulting, but I just use it to say, I understand the problem and concerns and how it impacts people, and hear about people not surviving this issue, and especially if they've been in front of me, it clearly it's heartbreaking. All right, the court's gonna release the defendant on a PR bond beginning on February 17th. At 2026. She will be transferred by, and this will have to be arranged through the Public Defender's Office. She'll be transferred through the West Express, which does do a service for the county, and we need to have that arranged ahead of time. Thankfully, West Express has worked with the county, and we use some of the opioid funding and other funds to help do that transportation. She will be transported to the Sunrise Center. She's ordered to participate in that program. If she leaves that program or she is terminated involuntarily, then her bond will be revoked and she'll have to return to jail. She will also sign a release that will allow community corrections from this court to monitor her attendance. Ms. Plum, what that means is community corrections will only have the ability to check that you're there. That's it. All right, is she there? Is she doing what she's supposed to? I want to highlight that for you so you don't think that anyone else outside of you and your counselors will know what you and your counselors talk about. I just need to know that you're doing what I told you to do. That's all. All right. Now, some of these programs, I can't remember if Sunrise Center does. And they say, well, we don't like to do these because of whatever. You can tell Sunrise Center that if they don't allow just community corrections to check that you're there, I'll have you put back in jail. So you want to make sure that they do as I say. Again, no one is going to know anything about your private communications, okay?
Okay, yes, sir.
I can't monitor you, at least your attendance. And why would I put somebody into a program?
Right.
Your sentencing is scheduled to come up the week after. But I will, if the parties tell me, and Mr. Harrison will be the one in charge of drafting a stipulation to say, hey, Judge, yeah, she's still there, then I'll continue in the program and we'll adjourn your sentencing. Clearly, I understand, and you should understand as well, that I'm using your sentencing to hang over your head. I'm not saying I'm going to punish you. It's not like a stick, but it's your way to convince me that I don't put you in prison. Okay?
Okay, yes, Your Honor. Thank you very much.
Yeah, it always sounds awkward, and it's not to be mean, but it's just to say, I'm hoping that you take this opportunity to do all the right stuff. And clearly, I understand that I have this sentence hanging over your head that will hopefully help encourage you to maximize your full benefit. Okay?
Okay, Your Honor. Thank you. Thank you very much for this.
Yep. And that means if they give you the opportunity for a sober living facility, I want you to stay in the sober living facility. Now, last thing. Stay away from, I'm not saying you did it. There's no fighting. Stay away from the people in Muskegon.
Yes, Your Honor.
Any further today, Mr. Harrison?
Nothing further, Your Honor.
Ms. Dahl?
No, Your Honor.
Devin, I really sincerely mean this. Good luck, because I'm very bothered. I didn't know about your mom, and I'm very sorry.
I'm sorry about that too, Your
That's
Honor.
okay.
I assumed that was common knowledge.
I haven't seen Mr. Cyber in a long time. Sorry to hear it. Are you Ruth Minkle? File number here is 252290. You're here with your lawyer, Mr. Timothy George. You're charged with operating with a high blood alcohol level. That's a misdemeanor. It's punishable by up to 180 days in jail, fine of up to $750. Requires that your license be suspended. And it carries 6 points. Prosecutors agreed to reduce that to a lesser charge of operating while intoxicated. That is a misdemeanor. It's punishable by up to 93 days in jail, fine of up to $500. It carries 6 points and requires your license be suspended. You got arrested on November 9th on the Big Hill at 131 and Drummond Road. They arrested you and they sent your blood to the crime lab and it came back at .247. Is that correct, Mr. George?
Your Honor, it came back at a .285.
285,
Yes,
okay.
the 247 was the preliminary test.
Ms. Minkle, are you going to plead to that charge of operating while intoxicated?
Yes. Yes, Your Honor.
Anybody threaten you to get you to do this?
No.
Or promise you anything? You understand that by entering this plea, you're gonna give up all those rights that were on the advice of right sheet that was, had you go ahead and sign it? Where were you going?
I was on my way back from Myers. I'd been to the store to get some cat food and some cat litter before it started snowing, and I was in the process of trying to stop drinking. I go to AA and I've been to rehab, and the doctor had given me Ativan for withdrawal symptoms. I took it at 4 o'clock in the morning because I woke up all shaky, and then I went back to bed, and then I noticed that there was no cat food, and so I thought, well, I'll go in before it starts snowing. So I went into Myers, and I was in Myers walking around about 1 o'clock, and I started shaking again, and I didn't have any Ativan or anything. And so I made the stupid decision of knowing that if I had a drink, it would take the shakes away. And I thought about it. There was nobody available to come and get me. And I live alone. I have no family around. I just have some neighbors which would have come and got me if they hadn't have been working. And so I made the stupidest mistake I've ever made in my life.
What did you drink?
So ashamed.
What did you drink?
Gin. I think it was a little bottle of gin. I didn't drink the whole bottle.
Well, you did. .247 is near the point where they have to take you to the hospital.
No, the officer poured it out on the floor.
Okay, did you have some alcohol in your system from before?
Because I was taking the Ativan to stop.
You're lucky you didn't kill yourself. I'm glad you didn't. Do you still live in Constantine?
Yes.
You really? You know how many points you have on your driver's license? 0.
I know.
You got a completely clean.
I have never drank, I swear to God, and got in my car before. So
Well, you almost croaked yourself and everybody else that was driving down 131. That's a very dangerous spot.
Yeah.
I can probably, within 30 seconds, name off 10 fatal traffic accidents right there at that spot.
You see, I feel that the Ativan that I had in my blood.
This wasn't the Ativan. This is
No,
alcohol.
I mean the mixture.
Well, it certainly made you more dangerous to drive on the road. People called 911 and said, hey, there's somebody in a red Equinox all over the road. And they stopped you. You told the officers you drank wine. But anyway, we'll try to get a handle on all this. This will be something we'll have to figure this out. So we're going to set it for screening and sentencing on a date that works for Mr. George. Tim, I've already got you set for some of those days.
I have March 2nd. I don't know if that's too full.
I think, let's see what we got. It was pretty full. No, that will work fine. You've
Okay.
got Mr. Kindig that morning. Let's set it for March 2nd. I've got some Jordan days that are quite full. When you say you've been to rehab, how recently was that?
In 24, and I was sober for a year. I got my coin. In fact, I have all my coins with me.
People have given me some coins over the years. I'm honored when they do, but I've got several. I've got a year coin.
And I've been seeing a therapist for two years, addiction therapist for 2 years.
All right, well, that's a good start. What kind of work did you do?
I was in nursing.
All right, I think I knew that. You had a different name. Horvath? What was your previous name? Hackworth?
I'm sorry?
What was your name before it was Minkle?
Oh, before?
Yeah.
Creighton.
Oh, all right.
I've been married twice and both my husbands were Vietnam vets and they both passed away.
Where are you from originally?
England originally. And I'm quarter Irish.
All right, we'll set this for March 2nd. At 11 o'clock. I want to know about your treatment, your AA attendance, all that stuff. We'll get more information about this.
And she did provide that. She has that documentation with her today, but we'll make sure that the probation
Very
department
good.
has
We'll
it.
get a head start.
Yes, sir.
All right, I'll see you on March 2nd at 11 o'clock.
Thank you, Your
You go
Honor.
with Mr. George. Paul will finish Tim's. I'm sorry, Jordan, and then we're gonna do Paul's in custody people. Because we need to get them out of here. I don't know why I thought her name was.
So while he racks up the next contestant, just some thoughts on the fourth hour today. I told you when we launched the fourth hour a few weeks ago that it would be a work in progress, and we'll evolve it and just kind of see. But I think it makes sense, and you tell me if you feel differently in the chat. I think it makes sense for Friday, for the fourth hour, to split it up. Do the first half hour of Dungeon Court, and then the second half hour of discussion, commentary, that sort of thing. Because we try to have a little bit more fun on Fridays here. So I'm thinking taking a half an hour of it for Dungeon Court. Let me know what you think of that in the chat. I think it makes sense, though.
Good morning, sir. Are you Dana Horvath?
Yes, Your Honor.
You're charged with malicious destruction of a building less than $200. They don't know how much the restitution is. Let's take a look at your ticket. Try to find your case. All right, Mr. Horvath, it's alleged that on or about April 7th of last year, you destroy a building on US 12 in Montville Township that belonged to Larry Pennell, less than $200. According to the affidavit, you got in an argument with your neighbor and kicked in his front door and broke the door frame. He admitted to kicking Larry's door. but you were mad about some comments he'd made about one of your relatives. And then you were charged with this. All right, malicious destruction of property, the way this is charged is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Doesn't affect your driving record at all. They allege this was worth less than $200. Do you understand the charge?
Yes, Your Honor.
Did anybody promise you anything to get you to plead to that charge? No. You don't appear to owe us anything. Tell me what happened.
Well, he had, he's been a good friend of mine, and I gave him a washing machine. It was his broke for his laundry. And that same night, he somehow got a hold of my cousin's wife and was trying to solicit her on the phone. So I went over there to tell him it was unacceptable behavior, and he did. And he slammed the door in my face, and I kicked the door in. And then I left. And I left him the washing machine. I told him he could keep it for the damages on the door.
Well, they've had from April till now to figure out how much this was. You posted $100 of bond. You spent one night in jail. I'm gonna order 1 day in jail credit, 1 day. I'm gonna order a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee, a $150 attorney fee, which makes this pretty expensive. That's $350. I'm gonna order $100 restitution to Larry Pennell. You have $100 of bond, so we'll pay him with your bond. The rest of it, if it's more than that, he can take it out of the washing machine, I guess. You know, $350. Can you pay that today or need time to pay it?
I can pay it today, right?
Very good. All right, this matter's done. Your bond's gonna be applied to the restitution. They can use that to pay him. This happened in April, it's now February. It took 10 months to get this resolved, but it's over with. You don't seem to owe us anything else. Spent a night in jail, which is probably no fun. For at least some time in jail. Mr. Horvath, you go out to the counter and pay that fine, and then you're good to go.
Thank you, Your Honor.
Thank you, Your Honor.
That's what I have, Your Honor, is Mr. Decker.
Gregory Decker. Good morning, sir. You Gregory Decker? File number is 252387. I don't know that I've met you much. Are you Greg Decker's son?
Yes.
Okay, that's what I thought I'd seen, but you're his son. We had a case like this earlier. You got charged with leaving the scene of a property damage accident. That carries 2 points. they're gonna allow this to be failed to report an accident to fixtures. 257621, that carries no points. Do you understand?
Yes.
Anybody promise you anything to get you to plead to that
No.
or threaten you?
No.
And do you understand by entering this plea, you're giving up all the rights on the advice of rights?
Yes.
All right, just like the last guy, tell me what happened.
I was on my way home and the rear end of my car started like shimmering. And I tried to save it, but I couldn't. Lost control.
Where were you coming from?
My grandpa's.
Which is where?
Pinhook Road in Mendon.
All right, M60 near Parkville. It was November 12th, 11:15 at night. What'd you hit?
I didn't hit anything.
Did you hit another car?
No.
Failed to stop an ID hit and run. So did your car, what happened to your car?
Brokers towed it.
All right, so you left it there on the side of the road?
Yes.
And then you walked to your grandpa's?
Yes.
All right, as I said, we often think these are drunk drivers that got away, which might be what this was. But it's going to show as a no. Darn it. Laura, I'm out of generic judgments. I got a bunch of assault and battery judgments, which I don't need. So I need some general ones. Well, doctor one up. I need some judgments, blank ones,
Just
the generic
general.
ones. What do you do, Mr. Decker? Do you work someplace?
Yes.
What kind of car? This was a 2009 Mercury. What did it do to the car?
Nothing really.
So what, the last guy, his car was totaled. They just towed it and then you had to go get it.
Yeah.
How much did it cost you to get out of impound?
600.
Oh boy. This is an expensive night. You live on Fifth Ave?
Yes.
All right, your dad used to live at Parkville, but he wasn't living at Parkville at that time?
No.
I didn't think this would be that hard, but all right, the fine is $75. Rest of these are costs. There's a $50 state minimum, $75 crime victims' rights fee, and $150 attorney fee, which makes $350. That's a lot. You owe $1,734 but I'm not sure they haven't confabulated your case with your father. Do you have that many unpaid tickets?
I don't believe so.
All right, we'll find out. Let's take a look at that. You're Gregory Dean Decker Jr.
Yes.
No, that's you, 20. I'm not sure everything is you, but some of them are. You got unpaid fines that you're gonna need to deal with. So I'm gonna put you on a payment plan. If you want, I put you in jail and wipe all these out. Would you rather do that? Or do a payment plan to pay your fines and costs?
Payment plan.
Yeah, I want you to do that. You've got multiple unpaid tickets back from last several years. And I want you to pay it. When did you last work?
Yesterday,
All right, where was that?
Vicksburg,
Where do you work?
GBS.
Okay, good. Well, then you should be able to set up a payment plan to pay on all these fines. All right, Mr. Decker, would you take them out to the counter?